Hello, my fellow Alaskans. How are we all out there today on this beautiful, beautiful snowy day here in Alaska? I don't know about you, but it has already begun to snow here in the Big Lake area in the Matsu Valley. It is another day of slip and slide. Try not to get stuck. I'm still waiting for the plow trucks to come and plow me out so that I can actually make it out of my driveway. They still haven't come down my road. I am still patiently waiting. So here we are once again. We're going to stream the stream coming directly from them in Palmer. And we are going to watch the case of Kowalke against Eastman. And the rights to our republic are on the line right now. And protecting our, as the Democrats always say, we got to protect our democracy. Well, we are, newsflash, going to protect our republic from democracy. Today in court, we will get to begin to hear the beginnings of testimony going to be given by many different witnesses why this lawsuit, or this particular trial case that's going on there in Palmer right at this moment, should be completely dismissed. It should have been dismissed the moment that it was filed. Unfortunately, our judicial branch here in Alaska thinks they are above the law, yuck, yuck, and that they have the full control and utter determination of who will be allowed to serve as our legislators and who will not be allowed to serve as our legislators. All because of a membership to a group called the Oath Keepers, which if you were to take the time to actually research them and their motto or their bylaws or whatever you may want to call their oath that they take, these are folks who are made up of police officers, military members, doctors, lawyers, you name it, anybody, firefighters that has served and protected us throughout time and believes in our republic and the Constitution of America and protecting all of our rights, yours, mine, and everyone else's. This case should be something that all of you should be wanting to pay attention to right now. Take a moment at this time. Please like and share this video. Is how we're going to be able to beat the Facebook algorithms, YouTube algorithms, and Twitter algorithms out there. The more we like, the more we share, the more this video is going to reach lots of Alaskans. And that's the whole entire goal here, is to keep us Alaskans educated, exposing what mainstream media and our far left government that is currently in control of Alaska, and the next 2 years is total destruction that is about to occur, don't want you to see. They want this case to be only televised or at least spoken about by those that are sitting in power, who will be allowed to actually serve and represent us down there in Juneau, and who will not. They have not liked David Eastman since day one. If they all had a choice, they would just kick him out because he's the only true conservative that we Alaskans have down in Juneau. Don't just take my word for it. Look at his record. He has a 100% record down there in Juneau as being the only conservative there. Something that none of the other legislators that we just recently elected, or the legislators that have been there forever, can ever claim. So today, hopefully you guys are all taking the time to at least share this, save this, something, do whatever you need to do to be able to watch this later on. But we are again here to expose what the mainstream media and the left do not want us to know about our upcoming elections and what is going on with them. So take a moment again, please like and share. You can find this video currently on Twitter, YouTube, and Facebook at Politadick and Politadick Unfiltered. You will also be able to find this on NorthTube. It takes a little bit to actually start the live feed there, but I am now streaming live on NorthTube. Found me another channel out there that'll keep me from being censored. And finding the videos completely blocked or banned, it is uncensored on NorthTube. You do not have to be have a subscription to NorthTube to be able to get notifications. Just go there, type in my name, Politadick. It will bring up all my videos that are currently there. We are transferring all over one by one. And you can also find us on Rumble. This video here should be found on Rumble within the next 12 hours as it mitigates over to their platform. And you guys can help me make it so that I can actually live stream to them by going to rumble.com, type in my name, Politadick, Politadick, into that search bar in Rumble, and subscribe to us. The faster we reach 100 subscribers, that's how much quicker we're going to be able to live stream directly onto Rumble. It takes 100 subscribers to live stream on Rumble. I can't understand why it's taking so long to get so many people over there. We have over 5,000 people here on Facebook watching this, or at least following us here on Facebook. And Facebook is doing everything they can to shadow ban this live feed to all of you. Help us defeat the mainstream media's censorship and banning of conservative voices, and making sure to like, share, and subscribe to channels that will actually send you notifications. If you're not a YouTube watcher, but you like watching these on Facebook, which many of us do that follow me here, go to YouTube and subscribe and make sure you hit that notification bell. Facebook is no longer notifying you that my videos are going live. YouTube, on the other hand, hasn't failed yet to broadcast I have gone live as long as you have the notification set. They're doing the same thing to the Michael Duke show early in the morning. It has been almost 3 weeks since I've received a Facebook notification that that show is live. But my YouTube notification has shown up every single time, and that is what matters. At least someone, somewhere, one of the platforms out there is actually sending me a notification something is happening, and that is how we defeat the narrative and what is going on. I just saw the screen flip there on the other side for the live feed. Hopefully that means they're just about ready to get things going here. I am going to go ahead and switch over to that and see what we can find out. Stay tuned, like, share, help us grow, support us. We'll see you a little bit later. Uh-oh. There we go.
All right, good morning, everybody. We're on record in Kowalke versus Eastman, 3AN 227404CIs. Time set for a bench trial. We have Mr. Dedukian here representing Mr. Kowalke. We have Mr. Miller here representing Representative Eastman. On the Zoom, we have Ms. Harrison representing the Division of Elections. Are the parties ready to go forward today?
Yes. Yes, Judge.
Ms. Harrison, are you there? Ms. Harrison, if you are there, you're muted. Glenn, are you there on the Zoom?
Yes, good morning, Your Honor. Lael should be attending. Let me make sure she's not having any issues. I think I see her popping on and off Zoom. Lael, can you hear us? It sounds like she can't hear anything. Let me go offline real quick and I'll try and connect with her. Thanks, Judge.
All right, we'll just give just a moment. We want to make sure the state's attorneys are able to hear us.
Your Honor, can you say something? Here, see if I can hear you.
Yes, Ms. Harrison, we can hear you now. Are you able to hear us?
Yes, thank you. It was wrong on my end. I've got it sorted.
Excellent. So we've got all the parties present. At this point, it sounds like we're ready for opening statements. My understanding is that we would hear first from Mr. Dedukian. Ms. Harrison, you then wanted to make a statement. And Mr. Miller, you're going to be reserving for when you begin your evidence.
That's right, Judge.
All right. All right, Mr. Dedukian.
Thank you, Your Honor. Good morning, and may it please the court. We're here for a historic trial. It's the first time that Article 12, Section 4 of the Alaska Constitution is being tested in court. I would also like to acknowledge the citizens and journalists who are following the trial in court today and on the live stream. There's a lot of public interest in the case, and that's as it should be. But all of that being said, the actual issues for trial are very simple. As the court stated in its recent orders, there are only two elements that we need to prove to win the case. The first element is that Representative Eastman aids or belongs to the Oath Keepers, and the second element is that the Oath Keepers advocates concrete action to overthrow the U.S. government or has actually engaged in such conduct. That language is from your orders. And we are going to present overwhelming evidence on both of those elements. The first one is easy because Representative Eastman is a founding lifetime member of the organization. He's contributed more than $1,000 in support to the organization. And even after the events of the January 6th insurrection and the recent conviction of founder Stuart Rhodes, he still has not taken any steps to resign his membership or renounce his membership, either publicly or privately. As to the second element, again, we're going to present overwhelming evidence that the Oath Keepers between the November 2020 presidential election and January 6th dangerously combined both insurrectionary rhetoric with seditious conduct. On their public website, the organization advocated for a, quote, bloody revolution against the current administration. They said that they were going to, quote, take to arms and fight, and they were going to fight either with or without President Trump's support, and whether or not he would call them up as a militia or not. And on January 6th, they did exactly what they said they were going to do. The Oath Keepers, led by founder Stuart Rhodes, by operations leader Michael Green, by state and county leaders of the organization, and with dozens of so-called patriots, traveled to Washington, D.C. They brought with them a large cache of ammunition, weapons, and tactical gear, and they had a singular purpose, which was to stop the transfer of presidential power. Some of the members who went to Washington were assigned to Quick Reaction Force teams, QRF teams. You're going to be hearing a lot about that. And they were stationed outside Washington, ready to fight on Rhodes' command. Another group of Oath Keepers were at the Capitol, and they were wearing combat gear and prominently displaying their Oath Keepers patches and insignia. They assembled when it became clear that the that Congress was going to certify Biden as the president. They assembled in a military stack formation. They overcame barriers. They illegally entered the Capitol building. And once they were inside the Capitol building, they used force. They assaulted the Capitol Police. They intimidated government personnel, and they literally went hunting for the Speaker of the House. And through all of that, they succeeded, at least temporarily, in delaying the certification of the election. And everything I said, everything I just said, you don't have to take my word for it. That's coming straight from the mouths of Oath Keepers who pled guilty for their actions on January 6th, including 3 who pled guilty to seditious conspiracy charges, and the recent conviction by a jury of Stuart Rhodes and other Oath Keepers for seditious conspiracy and other lesser included charges. And all told, there were 33 Oath Keepers charged as a result of January 6th. There were 9 guilty pleas and 5 convicted by a jury, and another trial is just starting, I believe, this week. You're going to hear from two of the most prominent experts on the Oath Keepers in this trial. The first one who's going to testify today is John Lewis. He's at the Program on Extremism at George Washington University. The other is Matt Kreiner, who's with the Center on Terrorism, Extremism, and Counterterrorism at Middlebury Institute. and they've both extensively studied and published on the Oath Keepers, and they were both invited by the Alaska legislature this past year to testify on the role of the Oath Keepers in the January 6th insurrection. Mr. Lewis, in his testimony today, is going to focus more on the recent events, the actions and statements of the Oath Keepers, starting right around the time of the election in November 2020 through January 6th and the aftermath. And he's also going to testify about the criminal prosecutions that were brought, the current status, and the convictions and guilty pleas. Mr. Kreiner is going to talk about the founding and the history of the organization, the organizational structure and its bylaws, the paramilitary operations and mobilizations before January 6th, including a series of armed standoffs with federal officers, and the online rhetoric, extremist rhetoric that was posted leading up to January 6th. Both experts are going to tell you that the Oath Keepers is an organization that advocates concrete action to overthrow the U.S. government and is actually engaged in such conduct. And as such, we're going to be asking the court to find that Representative Eastman is ineligible to hold public office under the Alaska Constitution. Thank you.
Harrison?
Thank you, Your Honor. First, I just have a procedural matter to put on record, which is that the case caption in this case needs to be updated. Ms. Fanumaniai, who is the named defendant right now for the Division of Elections, has retired, and there's a new acting director. So I'll work with the parties to get that caption updated going forward. I just want to let the court know.
Well, I would grant that motion.
Thank you. I recognize, Your Honor, I may be making this argument really as a record for appeal, but I do want to give the court an opportunity to consider these issues while this trial is pending. Your Honor, I think it should be clear at this point that the plaintiff has waived any claim that this is an administrative appeal from the Division of Elections decision. The original complaint did not allege jurisdiction of this court as an appellate court. It did not allege jurisdiction under AS 2210-020D. The division promptly moved to dismiss under Rule 12b-6 of the Rules of Civil Procedure. There was no objection to that, no suggestion that Appellate Rule 601 should apply, or those rules of the Superior Court acting as an appellate court. And in the opposing the motion to dismiss, the plaintiff very firmly stated this was not an administrative appeal. Then again, in the substantive arguments on the motion for summary judgment, the plaintiff was also very clear this was not an administrative appeal. And even to the extent that the plaintiff did talk about, well, what in the alternative, what standards of review might apply if this were an administrative appeal. The plaintiff never suggested anything about a trial de novo or discussed the standards for granting a trial de novo. Your Honor, so it's now we're at the first day of trial, and the plaintiff has never alleged that this is an administrative appeal, and that claim is waived. And respectfully, Your Honor, the court cannot bring a waived claim back to life unilaterally. And even, Your Honor, in your own order denying Representative Eastman's motion to compel that was issued on the same day as your order denying the division's motion for summary judgment, Your Honor recognized in footnote 3 that even now, Mr. Kowalke does not consider his claim to be an administrative appeal. In addition to being waived, Your Honor, there is, I think, a good argument here that it is in fact stopped. Your Honor, you yourself were the first person to suggest that this case might be a trial de novo on an administrative appeal. And Your Honor, you suggested that at the oral argument on the motion for summary judgment. If the plaintiffs had made that suggestion at oral argument, if the plaintiffs had at the first time said, well, this might be an administrative appeal and a trial de novo, I would have argued at that time that quasi-estoppel should apply. Quasi-estoppel, as you may be aware, is a doctrine that prevents a party from changing their litigation position late in litigation, particularly on the eve of trial, and particularly when defendant or the opposing party has relied on that litigation position in framing their defenses. So again, this court should not be able to unilaterally do what the plaintiffs would be stopped from doing. So again, I just want to emphasize, again, with respect, but from the division's point of view, that it was inappropriate to change the procedural posture of this case so late in the case, particularly without any request for supplemental briefing or forewarning. Another point I'd like to put on the record and give Your Honor, a chance to consider is that if this is a administrative appeal and a trial de novo, it is completely moot. 6 AAC 25260 is a procedure for taking someone's name off the primary election ballot. And the primary election has long since happened, and the general election has happened. If the plaintiffs had filed this case originally as an administrative appeal, there was briefing about the timing of it at the time, but there would certainly have been briefing about mootness and the timing of it being filed as an administrative appeal. And frankly, Your Honor, I think the plaintiff always knew or suspected that an administrative appeal would be moot by the time that he filed it, because since he waited 6 or 7 weeks from getting the division's decision to file anything, the time to really make a difference under an administrative appeal had already passed. The only claim for relief that wouldn't be moot at this point is the request to certify the election differently. And as we've discussed many times, that's an election contest remedy. At the end of the day, looking at the court's orders, it seems that the court actually agrees with the Division of Elections that there aren't 3 ways to bring this claim. There's an administrative appeal, which is now moot, and there's an election contest, which Mr. Kowalke is not qualified to file, and that's it. And this isn't either of those things. Therefore, we just return to our point that the division should be dismissed from the case. One other point to make finally before I conclude is regarding public policy. Your Honor, in your order, you stated that the division argues, I'm quoting here, that sound public policy argues against enforcing the disloyalty clause. I want to correct that. Your Honor, that is not the division's position. The division's position is that sound public policy argues against the division of election enforcing the disloyalty clause. That is the key difference. The Division of Elections certainly never taken the position that this court could not or should not enforce it, or that the legislature could not or should not enforce it. But it should not be up to the division to be the ones making that determination, conducting some kind of investigation, or being the enforcers of the disloyalty clause. And also with regards to public policy, Your Honor, the division isn't asking this court to make public policy. We're asking this court to apply public policy that's been made already by the appropriate bodies. The public policy that the division be neutral and impartial is stated by the legislature in the statutes creating the Division of Elections. So when this court is considering, how should I interpret this statute governing the Division of Elections, it's very appropriate to consider the policy created by the legislature that is supposed to apply to the Division of Elections. Similarly, the policy in favor of encouraging citizens to run for office is one that's been stated by the Alaska Supreme Court in the Begich and Warwick cases. So no one's asking this court to create new policy. It's simply a matter of applying policy created already by the appropriate bodies. That's really all I wanted to say, Your Honor. I understand at this point the division has really no role to play in this trial. We did file yesterday afternoon a stipulation of facts about the involvement in the division of this matter. So at this point, I intend to just sort of keep quiet, turn my camera off, mute my line. If for some reason I do wish to address the court, or I do wish to ask a cross-examination question of witness, I'll turn on my camera and find a way to signal that to you. But otherwise, I guess I would appreciate the opportunity to address this court one more time at the end of trial, but otherwise I expect not to participate. Thank you.
Thank you, Ms. Harrison. As you said, if there is something that you need to jump in on, just let us know and we'll try and make sure that we notice and give you an opportunity to be heard. But otherwise, I won't really check in with you other than at the beginning of the day when trials begin until we get to closing. So thank you.
That's perfect. Thank you, Your Honor.
Mr. Dedukian, are you ready with your first witness?
Yes, Your Honor. I believe he should be waiting in the
And Judge, do we want to address objections to the expert now? I know that we have up record the motion in limine that you've already decided. What I'd like to do is have the court grant me a continuing objection against both experts on the basis of those motions in limine that were denied, just so that the record is preserved. And I do have another generalized objection that I'd like to also submit for the court's consideration. And now might be a better time than waiting or having the witness online. I'll follow the court's.
It makes sense to me, Mr. Dudukian, to deal with this now as opposed to once we get into the middle of your testimony. So to the first request, I'll grant the continuing objection, noting what was raised in the motion work.
And Your Honor, then the secondary.
I apologize. I won't grant it, but I'll recognize it. So it's preserved.
Understood. Just so it's preserved. And if I can remain seated,
yes,
I address the court. The second issue is this is a very highly unusual trial on many different levels, as noted by the state in her arguments. The reality is, at least I have not been able to find a case that has been purely waged by way of experts with no fact witnesses. Certainly, we have a very liberal standard in Alaska for admissibility of experts. I understand that. In part, I think your ruling on the motion to eliminate recognized that. Marin versus Stromstad, I think, speaks directly to that, a recent case, 123 P3D 992. But when we're relying on experts exclusively for facts, which is what plaintiff is doing here, and plaintiff, of course, has the burden, it puts defendant in a very unusual situation. And I don't think that when we look to experts for assisting the court to find facts, that the Supreme Court anticipates those experts being the only vector for those facts to come into the court. Typically, there are facts at dispute that are introduced through fact witnesses. So we would object overall to a case which is presented exclusively through experts for the facts to be presented to the court. You'll find that when various exhibits are proposed by plaintiff, we're going to object to them on the same basis when they come in that, we believe that if, in fact, plaintiff was adequately prepared, wanted to bear its burden, it would have brought in fact witnesses to testify to the facts that they believe are at issue in this case. They would have subpoenaed, for example, various oath keepers. They would have subpoenaed people that had actually witnessed what happened on January 6th, or any other individual that had evidence that they believe relevant to the ultimate issue in the case, and that is whether or not the Oath Keepers is in fact an organization that advocates by force of violence for the overthrow of government. Of course, with the added kind of layer that your last order provided, the imminent incitement to the acts that lead to the overthrow of government. And so that is going to be the objection that I make to Mr. Lewis that is being introduced first as expert. It will be the same objection that I give to Mr. Kreiner when he's brought in within the next day or so. I can anticipate Your Honor's ruling on that, but I wanted to make sure that the record is clear that that is an objection to both of these witnesses by Representative Eastman.
Understood. And to the extent that at the moment I've overruled at least the motions in limine. Those were denied going both ways. I still haven't heard the evidence. I haven't heard the testimony. I agree with you that the general proposition that an expert can't be a conduit for hearsay just to kind of bring in an entire case, but I need to see it and hear it. And as we go forward, I understand that there'll be standing objections that are made. I'll rule on them as we go, recognizing this is also a bench trial, and so it's sort of in the realm of I can kind of sort out at the end as we get to it also where we're at and what evidence is actually coming and has been admissible. But to the extent we need to keep moving, I understand what the objection is. We'll probably deal with it shortly and then move on. But
so, Judge, if I can be granted a standing objection to both experts on that basis of using the experts as basically the exclusive conduit for facts, and of course also the motion in limine already stands for purposes of review. So, in other words, I don't want to waste the court's time. I want to create an efficiency for the court as well.
I appreciate that, and I understand it as a continuing objection. It's probably something we'll deal with at the end of the plaintiff's case.
Very well.
All right, Mr. Dudukian.
Is Mr. Lewis on? He is using yesterday's link. Is there says he's in the waiting room. Okay.
All right, Mr. Lewis, can you hear us?
Yes.
So, Mr. Lewis, are you in a position where we can have a conversation and you're not going to be interrupted?
Yes, sir.
Please raise your right hand. Do you swear or affirm that the statements you will provide in today's hearing are the truth, the whole truth, and nothing but the truth?
Yes.
Go ahead and put your hand down. Could you please spell both your first, or state both your first and last name and spell both for us, please?
Yes. Jonathan Lewis, Jonathan, Lewis, Lewis.
All right, thank you, sir. Mr. Dedukian, you may inquire, and you can remain seated as well if that's more comfortable and also easier to see.
Thank you. Good morning, Mr. Lewis. Can you hear me okay?
Yes.
We're doing this by Zoom. If you can't hear me at any point, please let me know. If any part of my question cuts out, instead of answering, please let me know and I'll rephrase it, okay?
Your Honor,
Yes.
if we could have him pull his mic a little closer to him, too.
All right. And, sir, where are you testifying from today?
Arlington, Virginia, my apartment.
Can you tell us about your current employment?
Yes, I am a research fellow with the program on extremism at George Washington University.
How long have you been in that position?
Since December 2018.
And can you tell us a little bit about the program on extremism?
Yes, the program on extremism is a nonpartisan research center housed at George Washington University. It provides data-driven primary source research related to issues of extremism, largely focused on extremism in the United States.
All right, and I guess before we go further, if we can just define some terms so that everybody's on the same page. When you say extremism, can you define what you mean by that?
Sure. So typically when we discuss extremism, namely violent extremism, which is the core focus of the program's work and my work, we'll usually hew to the definitional framework that the U.S. government provides, which bifurcates domestic violent extremism from homegrown violent extremism. And so when we discuss domestic violent extremism, we're discussing individuals who commit or plot to commit acts of violence in the homeland driven by a purely domestic ideology, whereas individuals who we define, or the U.S. government would define as homegrown violent extremists, are individuals who conduct similar activities with the view of either supporting a foreign terrorist organization or in furtherance of a specific foreign ideology.
So can you give us some examples of homegrown violent extremist groups?
Absolutely. So some of the prominent homegrown violent extremist mobilization we've seen in the U.S. in recent years have been supporters of foreign terrorist organizations such as the Islamic State, Al-Qaeda, Hamas, and Hezbollah, to name a few.
And can you give us some examples of domestic violent extremist groups?
Absolutely. So when we discuss domestic violent extremist groups, the two most prominent categories of those we see in terms of their offline mobilization have been what the U.S. government has referred to as REMV, racially ethnically motivated violent extremists, or anti-government and anti-authority violent extremists with the shorthand term AGAVE. And so for those, we typically see mobilization by neo-Nazi movements like Atomwaffen Division, the Base, or anti-government movements such as the Oath Keepers or perhaps the Three Percenters.
All right, and to clarify one thing, the groups that you just mentioned, are those AGAVE groups or REMV groups?
So the white supremacist or neo-Nazi groups such as Atomwaffen Division and the Base would go into that REM-V classification, whereas anti-government militias like the Oath Keepers would fall into the Agave category.
And I think you said that there, other than the Oath Keepers, what are some other examples of Agave groups?
Some of the prominent ones would be certainly the 3%er movement, this very loosely organized anti-government movement that operates in the United States, as well as the Boogaloo movement, which we saw emerge in 2020, which was characterized by individuals showing up to state capitals and state houses with their Hawaiian shirts and long rifles.
Can you tell us about your responsibilities as a research fellow at the program on extremism?
Absolutely. In my role as research fellow, I lead much of our domestic violent extremist research. So that includes conducting research, authoring publications, research reports, op-eds, giving media interviews as it relates to the mobilization of the groups that we just discussed, namely Oath Keepers, Proud Boys, neo-Nazi movements in the United States, as well as managing the program's repository of court records related to the 915 defendants we have seen charged by the DOJ in relation to the events of January 6 to date.
And let me follow up about the repository. Are part of your responsibilities managing that repository?
Yes, I manage the program's repository, the Capitol Hill Siege database, as we refer to it, that contains every single public court record that we have access to that corresponds to the defendants who have been charged federally in the District Court of Columbia by the Department of Justice for their criminal conduct in relation to the events of January 6, 2021.
So does the repository include the records from all of the Oath Keepers who were charged?
Yes, it includes charging documents, plea agreements, statements of offense, and where relevant, any motions or sentencing documents that have been made public to date.
Have you relied on the repository documents in your work?
Yes, I've relied extensively on the repository for my own work related to the events of January 6, including my research on the Oath Keepers, as well as my preparation for this trial.
And to your knowledge, have other experts in your field relied on the repository as well?
Yes, to my knowledge, it is the largest public repository of court records stemming from the events of January 6, and to my knowledge, both other experts in my field, members of the media, congressional committees have all relied extensively on both the repository itself and the research that the program has produced that is informed by those findings, that research as well.
And you mentioned congressional committees. Have congressional committees cited to the repository?
Yes, the January 6 Select Committee has several times, to my knowledge, and I believe several House and Senate committees during their hearings in the immediate aftermath of January 6 cited some of our preliminary findings as we were rolling that out in early 2021.
Did that include members of Congress on both sides of the aisle?
Yes, both Democrats and Republicans have frequently cited our underlying statistics as it relates to information such as demographics of defendants, military experience, and other pertinent data.
If I were to ask you to sum up your expertise in a few sentences, how would you do it?
My primary expertise since I joined the program on extremism has been domestic violent extremism and the evolution of domestic violent extremist movements, namely those REM-V and Agave buckets that we referenced earlier, the evolution of domestic violent extremist movements in the United States and the federal responses to that threat.
You alluded to this a little bit before, but have you studied the Oath Keepers as part of your research?
Yes, both before and after January 6th, the Oath Keepers were one of my primary areas of research due to their mobilization and their activities on January 6th.
And to define another term, when you talk about mobilization, what do you mean by that?
Yes, so when we describe offline mobilization, especially, we're referring to activities by the group that constitute significant patterns in terms of their offline activities. So if we see, again, as January 6th as an example, if you see a significant number of oath keepers together wearing their colors at a public event that receives significant attention, that would be one such data point in our analysis of mobilization.
And so when you look at the Oath Keepers or other similar organizations, are you drawing a distinction between their offline presence and their online presence?
Absolutely. I think both inform the research writ large, but I think it is important to say that there is a distinction, of course, between rhetoric speech, especially First Amendment protected speech, and offline mobilization, especially as it's connected to criminal activity or criminal conduct.
And when you say offline, are you just talking about in the real world?
Yes. Yeah. Yes. Real world physical activity by individuals. Yes.
Were you asked by my office to provide an opinion in connection with this case?
Yes.
What were you asked to provide an opinion on?
I was asked to provide an opinion on whether the Oath Keepers were an organization that called for and engaged in conduct related to January 6th and the overthrow of the U.S. government.
And what is your opinion on that issue?
My opinion is that both before and during January 6th, the Oath Keepers called for and attempted to execute a plan that would have resulted in the overthrow of the U.S. government on January 6th.
And when you say called for, are you talking about calling for concrete action, or are you talking about just abstract theory or principles?
Concrete action. The Oath Keepers, as a national organization led by Stuart Rhodes, called for specific activities to be taken by their members and their supporters, specifically targeting January 6th as that deadline when those activities must take place by. And by December 2020, you had both public and private messages from Stuart Rhodes to his supporters and followers that called them to the U.S. Capitol on January 6th with the specific intent of engaging in this seditious conspiracy to prevent the peaceful transfer of presidential power and ultimately overthrow the current state of the U.S. government.
And we're going to talk about some specific examples of that, but in addition to rhetoric, did the Oath Keepers also engage in actual conduct to overthrow the government?
Judge, I know this is a bench trial, but there's been a lot of leading, and I'm going to object at least to this question. And Your Honor, I mean, your courtroom, I'll defer to you and what you direct, but we'd like the same treatment, obviously, with our experts when they testify. But it should be the expert testifying, not counsel directing what the testimony would be.
Yes, please.
Your Honor, first of all, we're still on the foundational part of Mr. Lewis's testimony, and he's also an expert, and a lot more leeway for leading with experts. I mean, he can push back. He's obviously but again, we'll defer to the court. But I think that the question's not even close to the line of leading.
At least as far as the specific question itself, we are sort of in that, I take Mr. Dedukian's point, we're sort of in the foundational area. It also didn't suggest the answer in the form of the question. It was laying out a topic. But I also take Mr. Miller's point. I'm going to be relatively liberal with the parties as far as how they can ask their questions. We want to get the information out as quickly as possible. I can understand the difference if parties have a specific objection to a question that in the future, you should still raise the objection if you think it's there. But overall, we need to keep moving and get the answers out. So it's overruled to this objection.
I'll restate my question to Mr. Lewis. Are you still there?
Yes.
Did the Oath Keepers engage in actual conduct to overthrow the government?
Yes. In addition to planning, operational planning they conducted before January 6th, they also engaged in forceful activity on the grounds of the U.S. Capitol, breaching the U.S. Capitol building itself with the intent to obstruct the proceeding, prevent the certification of the electoral vote, and in essence, as the government has alluded to numerous times and charged numerous times, engage in a seditious conspiracy to prevent the peaceful transfer of presidential power on January 6th.
Right. Can you just briefly tell us about your educational background?
Yes, I have an undergraduate and a graduate degree from Rider University in Lawrenceville, New Jersey. The undergraduate is a double major in history and global studies, a minor in political science, and the master's degree is a master's in Homeland Security Policy that I obtained in 2017.
And do you have prior work experience in the field of domestic violent extremism?
Yes, I spent time in both the Combating Terrorism Center at West Point and the International Institute for Counterterrorism in Herzliya, Israel, examining all forms of extremism in the course of my time there before coming to the program on extremism in the fall of 2018 and full time in December of 2018.
When did you? I forgot to ask you. When did you get your master's degree?
Summer of 2017 was the conferral of the master's degree.
Have you published any articles on domestic violence extremism?
Yes, numerous articles on the areas of expertise I detailed earlier, namely white supremacist and anti-government violent extremist movements, the evolution of neo-Nazi movements, including Atomwaffen Division and the Base, as well as numerous long-form articles on the Oath Keepers, the Proud Boys, the Boogaloo movement, long-form reports on the evolution of those groups, their activities in January 6th, as well as a number of shorter op-eds on Stuart Rhodes and his organization, the Oath Keepers.
So, other than op-eds, have you published any articles on the Oath Keepers or Stuart Rhodes?
Yes, I published a long-form research article in the Combating Terrorism Center Sentinel, which at the time of publication in 2021 assessed the role of the Oath Keepers in the events of January 6th.
And is the CTC, is that the CTC Sentinel, can we call it the CTC Sentinel article?
Yes.
What is there? Is the CTC Sentinel associated with any institution?
Yes, it is. It is associated with the Combating Terrorism Center at West Point.
Is that the same West Point as the military academy?
Yes.
Did you have a co-author on that article?
Yes, Matthew Kreiner.
Have you worked with Mr. Kreiner since the article?
Yes, we've published numerous articles together, both before and after the publication of the Oath Keepers piece in question.
How big would you say the field of researchers or experts in domestic violent extremism is?
It's a relatively small field when you consider just domestic violent extremism. I would say a few dozen potentially as the ballpark number.
And is Mr. Kreiner regarded as an expert in your field?
Yes.
Have you heard of an individual by the name of Dr. John C. Eastman?
Yes.
And is he regarded as an expert in your field?
No, sir.
Have you ever testified in a court case before today?
No, sir.
Have you ever testified in a legislative hearing?
Yes, I testified before the Alaska House Military and Veterans Affairs Committee earlier this year.
And what were you asked to testify about?
The role of the Oath Keepers in the events January 6th.
Did you provide written testimony as well to the legislature?
I did, yes.
And can you explain how you came about testifying in the Alaska legislature? Were you invited or did you volunteer yourself?
Yes, I was connected with one of the staffers for Chris Tuck, who was seeking participants in the set of hearings they were scheduling, alongside Sam Jackson, who has authored the book on the Oath Keepers, as well as Matthew Kreiner.
And Mr. Lewis, you prepared an expert report for this case, right?
Yes, sir.
And the written testimony that you provided to the legislature that was appended to your report?
Yes.
And your report, and I should have asked you this at the outset, but do you have access to all of the exhibits that I sent you previously?
Yes, I have them right here on the screen next to me.
All right, your expert report is, has been marked as Exhibit 16. And I believe your testimony to the legislature was attached as Exhibit 2 to your report. Sorry, it might have been. It's Exhibit 3 to your report.
Yes.
And so was the title of your report, The Role of the Oath Keepers in the January 6th attack on the U.S. Capitol?
Yes.
And it has a date of February 10, 2022?
Yes.
And so are you looking at it right now?
Yes, the role of the Oath Keepers in the January 6th attack on the U.S. Capitol. My written testimony, correct.
And if you can scroll through it and confirm that that's a true and correct copy of the report you submitted to the legislature.
Yes, sir, it is.
Your Honor, at this time, we would move that in not for the truth of what's stated in the report, but just as something in regards to our claim against the division that was a state record that they could have accessed.
Starting with you, Mr. Miller, and then I will see if Ms. Harrison wants to weigh in on this as well.
So maybe I missed something. Is counsel asking for the entirety of 16 to come in right now?
I'm understanding this as they're Exhibit 16, but only Exhibit 3 to that attached to Mr. Lewis's report. Is that correct, Mr. Dudukian?
That's correct, and I can remark it and I can produce a separate standalone exhibit just to avoid confusion.
That'd probably be helpful to,
Yeah.
just so that's clear. But as to that request, Mr. Miller, I'll start with you just to give our state witnesses a chance to prep if they need to come back on.
Yeah, I mean, my continuing objection stands. I'm probably going to object to all of his exhibits, including this one. And I expected this to come in as an expert report. That's how it's been submitted. That's how it was provided to us. I think it's premature, and I think it would also confuse things to piecemeal this report in separate exhibits. I mean, again, I'll defer to the court as to how the court wants to deal with this, but if we're going to chop this up and submit it into multiple different exhibits, it's certainly not anything that we were prepared for. We filed our written objections to the exhibits, not based upon this being multiple exhibits, but one. So I would suggest that because it's not been marked separately or proffered separately, that it only comes in if admitted under Exhibit 16, which is the entire report. And of course, we're going to object to the report.
Understood. Ms. Harrison, I know I said I wouldn't be turning to you, but this exhibit's been offered essentially as part of what I understand is the plaintiff's case involving the division. It didn't seem to me like it was part of the stipulation, and so that's why I'm turning to you. And do you understand the issue that's raised?
I do. Your Honor, you are correct that this is not something that was part of the Division of Elections record on which they made their decision. So I suppose, it depends on what purpose it is being offered for. We don't object to it, if to the extent it's being offered in the case against Mr. Eastman, but you're correct, it is not something that was in the record for the division.
And Judge, if I could also be heard one more time, the parties offered a stipulation on facts, and that stipulation includes, and I'm not here to defend the state, but it states what was available to the state. And included in that stipulation is not this exhibit, so on that basis alone, I would object to its admission. The proper basis for this, as I understand it, is that this is something that the division had. The stipulation says it's not. So I think it's counter to the stipulation. Maybe plaintiff's counsel can explain how it's consistent with that stipulation.
I'm happy to explain further.
Please go ahead.
I'm not suggesting that this was in the custody of the division, but the regulation, I believe it's 68 FAC. Paragraph C, if you recall, has different provisions. One is that the division is required to consider evidence in its custody, but then it has the discretion to consider other evidence on file with the state. something that was on file with the state that the division could have considered. And I made the same argument at our hearing last week, so
And
Your Honor, if I may, go ahead,
I also
Mr.
wanted, well, I'll let Ms. Harrison, since understanding this generally is an exhibit involving the division. Ms. Harrison?
Yes, Your Honor, I understand that the plaintiff's counsel has represented that this is something that's on file with the state. I have not, that was not part of their motion. I haven't seen proof of that. I don't think that I can stipulate that this was something on file with the state because I just don't have that information before me now.
So my understanding is that the plaintiff is admitting or attempting to have this admitted into evidence based on Mr. Lewis's testimony that he gave what is the subpart Exhibit 3 to his expert report to the legislature. And so the point then is that it was in the legislature's possession. Is that the purpose of the exhibit?
absolutely correct.
Okay. And so, Ms. Harrison, it doesn't sound like he's saying it's part of the stipulation of the division had it. It sounds like it's going to whether or not there were additional public records to the extent that there may have been some. Does that clear up questions? And then based on that understanding of it, do you have an objection to it being admitted into evidence?
Your Honor, no, there's no objection to it being admitted into evidence, provided that it is supported by testimony, which Mr. Lewis has been giving regarding how it was used and what this document is, that provided that the foundation is supplied. We don't object.
And Your Honor, hearing what the purpose, again, I know this is primarily the state's issue, but if it's not being authenticated, which at least at this point, we don't have anybody from the state saying that it's part of the state files or anybody from the legislature saying that it's part of the legislator's files, then I don't think it comes in independently of the report itself. You know, all we have is the argument currently of the expert that he gave testimony. We don't have anybody from the legislature saying that they received this report, that is part of the legislative files, that this is actually the report that they have. That's typically how evidence of this nature comes into court. There has to be some degree of authentication, somebody in the legislature that says, yes, this is a report that we have. We don't have that.
I understand. So, Mr. Dukian, could you just, I'm going to need a little bit more about how this document was provided to the legislature and who actually gave it, essentially.
Understood. Mr. Lewis, are you still with us?
Yes, sir.
So before we started addressing the court about the exhibit, I had asked you about your written comments or testimony to the Alaska legislature about, which I was asking you about the one that was appended to your expert report. Did you provide that to anyone associated with the legislature?
Yes, sir. It was provided to the staffer for Representative Chris Tuck and subsequently posted on the Alaska State Legislature website alongside the video recording of the hearing itself.
And what was your understanding as to the purpose for why you were providing these written comments in addition to your oral testimony?
My understanding was that my written comments would support my oral discussion at the hearing that took place regarding the role of the Oath Keepers in the events of January 6th.
Was your written testimony provided before or after your oral testimony?
Before.
When you had the actual hearing and you provided your oral testimony, did you reference the report or get any questions about the report?
Yes, I believe I received questions about both my comments during the hearing as well as several facts specific to the written testimony that I provided.
Your Honor, again, I would move for the admission.
And I understand the objection that was raised by Mr. Miller. I also understand at least the points made by Ms. Harrison. I will find this needs to be marked separately. Do you have exhibit? Is it 44 would be the next in your numbering, or is it?
It's going to be 46.
Exhibit 3 to Exhibit 16, and admitted for the limited purpose that that document was given to the legislature and as part of the hearing.
And just so I'm clear, do you want me to prepare a new exhibit?
It would be helpful to sometime tomorrow, just to have that in as a separate exhibit so we have a clean copy of it.
So, Mr. Lewis, I want to shift gears a little bit and ask you about the data you considered in preparing or in conducting your research in this case. Can you tell us generally the categories of information that you considered?
Yeah. So I considered all relevant court records for the now 33 Oath Keepers defendants who have been charged federally in relation to the events of January 6th, as well as evidence and exhibits that were made publicly available, introduced by the federal government in the recent seditious conspiracy trial of Stuart Rhodes and 4 of his Oath Keepers co-defendants. Additionally, I reviewed a tranche of public statements that were made by Stuart Rhodes, both in his speeches, in interviews, as well as national calls to action and other letters that he had posted on the Oath Keepers national website.
And so now I want to ask you about some specific documents. Can you look at exhibit number 13?
Yes, exhibit 13.
Do you recognize that document?
Yes.
And the one that you're looking at is base numbered by the state, so ignore that for purposes of these questions, but what do you recognize this document as?
Yes, this is the original seditious conspiracy indictment filed by the government in January of 2022, charging Stuart Rhodes and his Oath Keeper co-defendants with, amongst other things, seditious conspiracy related to their conduct in the build-up to and ultimately at the U.S. Capitol on January 6, 2021.
And what about exhibit 20? Do you recognize that document?
Yes.
What is exhibit 20?
This is a superseding indictment filed by the Department of Justice in that same criminal case, also against Stuart Rhodes and his co-defendants with a near exact set of charges and set of overt acts the government articulated as conduct that would rise to the level of seditious conspiracy.
To your knowledge, is this exhibit 20 superseding indictment the last one that was filed in the case?
Yes, this is the most recent indictment filed in the case of USA versus Rhodes et al.
Did you consider these charging documents against Rhodes and his co-defendants in conducting your research in this case?
Yes, sir.
Starting at exhibit 22 and even numbers after that, so 22, 24, et cetera, until 38 are a series of plea agreements. Can you just go or thumb through those and let us know if you recognize those documents?
I do, yes.
Can you tell us what they are?
Yes, they are plea agreements for Oath Keepers, members and affiliates who had been charged in relation to their conduct on January 6th and who were pleading guilty to a range of charges, either seditious conspiracy or conspiring to obstruct the official proceeding, or in the case of John Schaefer, a felony count of obstructing an official proceeding, I believe.
And with regard to the indictments that I asked you about, are those included in the repository that you manage?
Yes, all of these documents are included in the public repository available on the program's website.
Okay, so the charging documents are the plea agreements included?
Yes, the charging documents, the plea agreements, as well as the statements of offense are all included. Yes, sir.
And the statements of offense, if you look at exhibit 23, is that one such example?
Yes, it is.
And if you look at the even numbers starting from 23 to 39, there's a series of statements of offense. Can you just take a moment to look at those?
Counsel, what exhibits?
23 to 39, the odd numbers.
Yes, sir.
What do you recognize those documents as?
Those are the accompanying statements of offense for the aforementioned Oath Keepers defendants that were tied to their plea agreements in these January 6 cases.
And did you consider the statements of offense in your conducting your study in this case?
Yes, sir.
And I believe you said that you considered various other filings from the federal cases, is that correct?
Yes, sir.
Give some examples of other sorts of filings that you considered.
Yes, sir. There were a series of motions filed in 2021 and 2022 by both the government and defense, namely surrounding pretrial issues such as pretrial detention or attempts by the defense to dismiss specific counts of the indictment, and then the response documents by the government in those specific motion cases. Additionally, I reviewed a handful of the trial transcripts that were publicly available in the cases related to some of these pleas, as well as those that were publicly available as it relates to the recently decided seditious conspiracy trial of Stewart Rhodes and 4 of his co-defendants.
Did you review any transcripts of Oath Keepers meetings?
Yes, the November 9th go-to meeting, which was provided as was provided by the U.S. government in this ongoing case, I reviewed.
Let me see if I can. We'll come to that in a second. Did you review any video footage of the events on January 6th?
Yes, I reviewed significant amounts of video footage as it relates to the events of January 6th, namely the actions of the Oath Keepers as they were available on restricted Capitol grounds and also inside the Capitol building on January 6th.
Did you provide an accounting of all of the information you considered in your expert report?
Yes, sir.
Are all of these categories of information and documents and videos that you considered the types of materials that are reasonably relied upon by experts in your field?
Yes, sir.
Right. We're going to come back to some of those documents in a minute, but if we can step back and have you provide some general background on who the Oath Keepers are as an organization.
Absolutely. The Oath Keepers are best described as an anti-government militia that was formed in April 2009 by Elmer Stewart Rhodes. It had long acted as a organization that was preoccupied by a seemingly inevitable conflict with the U.S. government and its representatives. Over its lifespan, it frequently engaged in acts of brinkmanship, which it hoped would lead to this spark that lights the fire, that would lead to this kind of all-out engagement that the Oath Keepers, again, believed was inevitable. And so as an extension of Stewart Rhodes, who throughout the lifespan of the Oath Keepers from 2009 to present has acted as not just the founder, but as the president and by their bylaws, lifetime chairman of the board, acted as an extension of his views, of his anti-government beliefs, and of his increasingly conspiratorial thinking towards the U.S. government and its perceived totalitarianism.
Is the Oath Keepers considered to be a militia group?
Yes, sir.
And I know you testified to some of it already, but what would you say are the central tenets of the organization?
The organization was formed in a time where there was significant social, economic, and individual uncertainty in the country. In the midst of an economic recession, as many veterans were returning home from wars overseas, as the nation elected its first African American president. This was a group that saw that turmoil, recognized the uncertainty, and then sought to capitalize on it. So really, when you look at Rhodes, when you look at the Oath Keepers as an organization, they were really formed with the idea that these conspiratorial views would become part and parcel of their mindset, that by clouding and kind of cloaking their conspiracies as reality, that they could paint themselves as these constitutional defenders of the republic, that again, in this impending conflict that was coming, the Oath Keepers would stand between the average American and the dark forces of the deep state, or the Chinese Communist Party, or the globalist forces of George Soros. And time again, as we've seen from the Oath Keepers, they attempted to insert themselves into these flashpoints in an attempt to gain legitimacy, gain relevance, and be viewed by their peers in the anti-government movement as some significant element of it.
And so I want to follow up with you on two of the things that you mentioned. One of the things you mentioned was flashpoints, and earlier you had mentioned brinksmanship. Are those, in your mind, the same or similar things that you were referring to?
Yes. So when you look at many of these significant flashpoints that you saw offline activity by the Oath Keepers at prior to January 6th, you saw them attempting to fan the flames and, invite this conflict in the hopes that they would be able to be viewed as, again, defenders, that they could paint themselves as being forced into defensive action, and again, fall back on these kind of twisted ideals of patriotism and try and wrap themselves in this version of the American flag, when in reality, they viewed these flashpoints as opportunities to further their own goals.
And when you mentioned conspiratorial views, can you summarize for us some of the conspiratorial views that have shaped the ideology of the Oath Keepers?
Absolutely. The first and foremost, I think when you look at the foundation of the group, it's the predominant element of it is that this unwieldy federal government led by the nation's first African American president would sweep into every small town America, take the guns away, and put every American in a FEMA camp. And what they saw was, every public action by the government in the years that followed was merely evidence to those conspiracies. And over time, what you saw was the Oath Keepers, not just as individuals, but as a national entity, as an extension of Stuart Rhodes's will, really embraced every right-wing conspiracy theory that gained traction within these ecosystems. And it's important to think of a lot of these spaces as echo chambers, right? When you have these really, small focused cells of individuals, these local chapters of Oath Keepers who are getting the same information from everyone around them. It's very, very easy for these conspiracies to become the only reasonable assumption that they can make. And so when you look at things like Stop the Steal, for example, this came on the heels of COVID-19 and the BLM racial justice protests in the summer, which really inflamed a lot of passions on the right and led to a whole host of conspiracies and conspiratorial thinking. And so by the time you get to fall 2020, what you have is an organization that has already steeped itself in these dangerous conspiracies, has already ingratiated itself in this right-wing ecosystem, and whose leader, Stuart Rhodes, is in many ways leading the charge and calling for voter fraud and saying that the left is going to steal this election, just like they tried to do in 2016, before the election is even decided, before the first in-person ballot is even cast.
All right, and the name Oath Keepers, where did that come from?
Yeah, it's an attempt by Stuart Rhodes to lean into this idea of patriotism and say that the Oath Keepers are an extension of the oath you take to the Constitution to this country when you join the military, when you're sworn in as a member of law enforcement or as an elected official. And that was really part and parcel of their propaganda efforts to paint themselves as merely a veteran service organization or a patriotic group that was just interested in protecting and serving the American people, and that the idea that they were merely following their constitutional direction laid out by the founding fathers was really an attempt by Rhodes to leverage the patriotism of average Americans into his own anti-government ideologies.
So if you were to just look at the language of the oath that the Oath Keepers take and compare it to the language of the oath that, say, a legislator would take, is the language of the oath similar?
Yes, it is. And that's an important point to make once again, which is that the Oath Keepers relied on that patriotism by first responders, by members of the military, by veterans and members of law enforcement, who many of them, by all accounts, truly bought in to this myth that the Oath Keepers were those defenders of the Republic, because they saw, hey, these individuals are swearing an oath just like we did. They're claiming to be constitutionalists. They're claiming that their only interest here is to, preserve American freedoms and stand up for democracy, when in reality it was a group that, again, due to the actions and ideology of Stuart Rhodes, had since its foundation been centered solely on anti-government activity.
So let me ask you this: if the language of the oath is similar, is there a peculiar way in which the Oath Keepers understand the oath?
Absolutely. I think when you look at the Oath Keepers from their foundation through January 6th, they saw themselves as the individuals who were the arbiters of what was and wasn't constitutional, what was and wasn't a constitutional order. They, in their minds, were the ones who were. It was up to them to make those decisions. There was no higher power than themselves, because again, when you are so deeply embracing those conspiracies, anything that you don't like or anything you disagree with can very easily be twisted as unconstitutional or unlawful.
And so would what you said, does it make a difference if a court has interpreted the Constitution in a given way, or if a different branch of government has interpreted the Constitution? Or do Oath Keepers believe that each individual gets to decide what's constitutional?
They believe that every individual Oath Keeper, or that the national brand of the Oath Keepers were the arbiters. They believe that if something was not going the way they thought it should, like the 2020 election, that this cannot be a normal constitutional functioning of society or of government, and as a result, it must be a conspiracy from their political enemies, and therefore something they must combat.
Can you tell us about whether the organization, the Oath Keepers, has a legal status?
Yes, to the best of my knowledge, they are currently incorporated in the state of Nevada as a legal entity.
And to your knowledge, has the entity been dissolved?
Not to my knowledge, no.
Can you tell us about membership? How many individuals, to the best of your knowledge, are in the Oath Keepers?
The Oath Keepers have claimed membership upwards of 38,000. It's always worth saying, as an extremism researcher, that they have tended to inflate those numbers over time, and that these numbers were ones that counted every individual who at one time signed up for a mailing list or bought a sticker or a pin or something of that kind. But 38,000, I think in recent times has been the number that both Rhodes has stuck to.
And over the course of their history, did the Oath Keepers try to recruit a certain kind of membership?
Yes, they frequently, from their foundation, sought out active members of the military and veterans, members of law enforcement community, namely local law enforcement, sheriffs especially, as well as first responders. And this was done for a couple key reasons. The first is that in the eyes of Rhodes and the Oath Keepers, these were individuals who he knew were loyal, who had sworn an oath to the Constitution. And again, as we just discussed, he believed that that idea of patriotism could be twisted and warped from within by the Oath Keepers. And also practically, from a tactical standpoint, Rhodes ran the organization in a very hierarchical military sense, using military jargon and frequently referencing things in a very particular military and law enforcement sense. And as a result of that, he saw the life experience, whether it's first aid, emergency response, weapons training, tactical training, training and experience in conflict situations as very, very valuable for the Oath Keepers as they sought to set themselves apart as one of the largest, if not the largest, anti-government militias in the United States.
All right, I want to shift gears again and talk to you a bit about the criminal prosecutions or charges brought against Oath Keepers after the January 6th events. To your knowledge, were any Oath Keepers charged for their conduct on January 6th?
Yes, to date, 33 Oath Keepers have been charged federally by the Department of Justice in relation to their conduct at the U.S. Capitol on January 6, 2021.
And we don't need to go through each individual who was charged, but what are the different categories of charges or types of charges that were brought against these individuals?
Yes, sir. So it's important to first understand that the 24 individuals have been charged out of those 33 as part of this overlapping conspiracy. The core goal of this conspiracy, as it's been charged in, I believe, the cases of 12 of those 24, was 18 U.S. Code 2384 seditious conspiracy. The government secured guilty pleas from, I believe, 3 of those individuals prior to the federal trials that began last month. They secured 2 convictions in the federal case in recent weeks against Stuart Rhodes, again, the founder, leader, and lifetime chairman of the board, as well as Kelly Meggs, the leader of the Oath Keepers Florida contingent at the U.S. Capitol on January 6. There are 4 more individuals related to that seditious conspiracy who are currently on trial in the D.C. District Court. Opening statements began today. They're also charged with seditious conspiracy, as well as several other related conspiracy charges, including conspiring to obstruct the official proceeding and conspiring to prevent an officer or official from discharging their duties. There will be another trial of the final subset of defendants who are only charged with 18 U.S.C. 1512, which is that obstruction of an official proceeding charge. They are set to go to trial in February. I believe the government has secured guilty pleas on 4 of those such defendants before trial.
So just to kind of break the numbers down a little bit more, so of the 33 who were charged, how many pled guilty?
7 have currently pleaded guilty to one of the various conspiracy charges as it relates to the conspiracy, the top-down hierarchical conspiracy by Rhodes and his co-defendants. There have been a handful of other pleas by Oath Keepers that do not relate to the conspiracy itself.
And just limiting it to seditious conspiracy charges, how many individuals pleaded guilty to that charge?
3 individuals have pleaded guilty to seditious conspiracy, and 2 additional have been recently convicted of that charge.
Who were the 3 that pleaded guilty?
I would have to reference my report very quickly if that's possible.
You don't need to do that. We're going to get into it in a second. Do you know which 2 were convicted?
Yes, Stuart Rhodes and Kelly Meggs were convicted by a jury in the District of Columbia.
So earlier I was asking you to look at the plea agreements that are in our exhibit list. And just to take one as an example, if you look at Exhibit 22,
Yes.
do you recognize that document?
Yes, this is one of the 3 seditious conspiracy plea agreements that the government obtained prior to the start of federal trials.
And who is the individual that pleaded guilty in this agreement?
This is William Todd Wilson, one of the North Carolina county leads for the Oath Keepers.
And if you look at the very top of the first page of the plea agreement, there's a blue stamp on it. Does that stamp mean anything to you?
I'm sorry, the stamp at the top of Exhibit 22?
Yeah, it's case 1.22-CR.
Yes, the stamp in the top left corner is the seal of the Department of Justice.
No, the numbers above the seal.
Oh, I'm sorry. Yes, that is the criminal case number for the Stewart Rhodes et al. Case, to the best of my recollection.
And was this agreement signed by Mr. Wilson?
Yes.
If you look at paragraph 1 of the agreement, did the agreement list out specifically the charges that Mr. Wilson was pleading guilty to?
Yes, it does. It specifies that counts 1 and 2 of the information which he's pleading guilty to are seditious conspiracy, 18 U.S.C. 2384, and obstructing an official proceeding, which is 18 U.S.C. 1512 C2.
Did it also specify the potential terms of imprisonment for those charges?
Yes, both carry a maximum sentence of 20 years imprisonment.
And if you look at paragraph 2 of the plea agreement, did it require factual stipulations by Mr. Wilson?
Yes.
And did Mr. Wilson comply with that requirement?
He did.
And if you could turn to Exhibit 23.
Yes.
Do you recognize that document?
Yes, this is the accompanying statement of offense for William Todd Wilson.
And is this the statement of offense that was submitted in compliance with paragraph 2 of the plea agreement, to your knowledge?
It was, yes.
And can you just give us, well, reading the last sentence of the introductory paragraph, what exactly was the purpose of this statement of offense?
And Judge, I'm, again, recognizing and respecting the efficiency of the court. I'm going to object to all of this testimony regarding these indictments and plea agreements on a relevancy basis, a variety of reasons. I mean, one of which we don't even know who these people are, their position in the organization, whether they have leadership or not. None of that has been provided in testimony. The only thing that we know is Stewart Rhodes is the leader. Otherwise, what we have are just a handful of 33 out of 38,000 oath keepers that have been charged with crimes that purportedly, according to these documents that aren't self-authenticating, they pled to or were convicted for and or entered into plea agreements for. Certainly, this expert has testified that he's relied on these indictments, but, and I suppose Your Honor could consider them in that context, but there has not been any nexus created for purposes of relevancy with respect to these random individuals who we know nothing about other than Stewart Rhodes.
Yes, Your Honor. First of all, we are going to be offering Exhibits 22, 39 into evidence, so I guess this is a good time to take that up. Half of those exhibits, the even numbered ones, are the plea agreements, and the odd numbered ones are the statements of offense. And I want to make a few different responses. As far as relevance and who these people are, I was just getting into my questioning of Mr. Lewis, but statements do clarify who, or a lot of them do, what position they had in the Oath Keepers organization. For example, Mr. Wilson, who we were talking about, was a county leader of the Oath Keepers. The plea agreements, all of these documents, Mr. Lewis testified, are in the repository that not only he relies on, but other experts in the field rely on. So they definitely could come in to support his opinion under Evidence Rule 703. And the guilty pleas themselves the court can take judicial notice of guilty pleas and the convictions themselves. And the statements of offense should come in under, if I can have a moment to pull up. Under Rule 804, D4, D3 as statements against interest. First of all, the authenticity of these documents cannot be seriously questioned. They're filed with the court's docket in the respective criminal cases. They're in the repository that Mr. Lewis testified about. And so I don't think the authenticity can be seriously questioned. These individuals are all out of state and in the middle of criminal proceedings. They have not, even though they've pleaded guilty, none of them have been sentenced yet, so they're still awaiting sentencing. So they're unavailable in this trial. And it's obvious that these statements are against their interest because they are subjecting them to 20 years of incarceration potentially for admitting to the facts that they admitted to in the statements of offense. So I think they certainly can come in under Rule 703, and they can also come in under 804B3.
They certainly are not self-authenticating documents. The plaintiff bears the burden in this case. If they wanted to bring in live witnesses to testify, they had that opportunity. The excuse that they're incarcerated or otherwise they're out of state and therefore it's too much of a burden for them to bring them in. I mean, given the weight of importance of this case where they're trying to remove a sitting legislator voted into office by a majority of his district on the basis of a court proceeding, suggests that maybe they should have done their homework and brought in witnesses to testify to these things, as opposed to trying to bring these documents in under this concept that they're self-authenticating. There's not a provision in the rules that allows for that.
I don't think he's arguing that they're self-authenticating. You know, they're certainly not certified documents, and so I agree with you that they're not being offered under that purpose. He's offering them under the theory that they're part of a repository. As you acknowledged earlier, that was their theory, right? That these are documents that an expert would normally rely upon in forming their opinion, and secondly, that these are statements against interest, essentially. But those are, I think, the two bases that the plaintiff is moving under.
And I don't think the statements against interest work in this context. As far as the expert relying on these documents, you know, obviously he can testify to what he relied on. That doesn't suddenly allow these to be kind of brought in because he relied on them. I mean, there would be absolutely no rule of evidence that needs to even apply then if you bring an expert into a case. All the expert has to say, hey, I looked at these things, I relied on them, therefore they come in. I suppose Your Honor could let them in for the limited purpose of these are documents he relied on, but they don't have any independent evidentiary value at all. I mean, I suppose that we could probably go through them with the expert and try to impeach his conclusions from them. So there is some benefit, I suppose, in that, but they don't hold independent evidentiary value. In other words, these documents do not provide evidence, for example, that these people were convicted of these crimes, that they admitted to them. They need to bring in additional evidence to support that. And you know, Your Honor allows these in under that rubric, then I suppose that fair play. I mean, we can do the same in the presentation of our case, but it doesn't seem that there's any traditional rule of evidence that will allow these to come in for independent evidentiary benefit to this case, other than the fact that he relied on these documents.
So I'm going to admit them under the theory that they are part of the repository of what he has relied upon. I am going to, though, reserve ruling on how much I'm going to rely on the statements within them. I want to take a closer look at what's in there and put a little bit of thought process. I understand the objection that's been raised by Mr. Miller, and I want to put a little bit more thought into how much the actual statements themselves might need additional support. So to the extent I'm going to admit 22 through 39 for at least that purpose or under that rationale at the moment. Secondly, Council, we've been going for about an hour and a half now. I could probably use a break, and I'm sure other folks could probably use one as well. Just timing-wise, Mr. Dedukian, how much more time do you think you have on direct with Mr. Lewis here?
I think about 2 hours.
Okay. Well, timing-wise, I think what we'll do is we'll come back at 11:20. That should give enough time for our staff also to wrap up stuff, and if they need to step out, to step out. So we'll come back on at 11:20. We'll probably go until about 12:30 or so. Let parties take a break to eat some food if they need to get some lunch. I understand, you know, we're still going until 4:30, so we need to recognize people need to refuel during the day, and then we'll finish up with Mr. Lewis after that. So for your planning purposes, that's where we're going to be at. So we'll be back at 11:20. We stand in recess.
wow. Absolutely wow. Okay, so their expert witness that they've had up on the stand, this is for the plaintiff right now, has provided absolutely nothing other than his opinion. And we are supposed to base a determination on the outcome of this case based on his opinions, his expert opinions. I can't emphasize that enough. This is hearsay. There is no actual evidence anywhere that has been provided that shows that Eastman has been involved directly with anything that occurred on January 6th. This is the same game that they play over and over and over again. We watched the witch hunt trials that they performed on our President Trump when he was in office, the current witch trials that they are performing right now, and trying to prosecute him, the raiding of his home at Mar-a-Lago by the FBI, and the January 6th committee and their defense on how they keep trying, we've got Trump now! And yet, after 6 years of investigations, they have absolutely nothing. Yet those that actually have evidence behind everything in the corruption that they're involved in, Biden, those investigations are not happening. They are silent. There's nothing occurring in that direction, even though the evidence is there. We've seen the gun. We've seen the gun with the smoke coming out of the barrel. And it's been handed to them on a silver platter, and yet not a single investigation happens in that direction. So they're going to come back at 11:20. I'm going to leave this live stream up and running. I'm not going to shut it down. Take a moment right now to like and share this video if you haven't done it already. Please do it now. It's only way we are going to be able to defeat the algorithms that they have out there that are shadow banning and censoring videos like this one from reaching as many people as possible. Back in 2017, if I was to run a live stream like this one right now, I wouldn't be surprised to see thousands, I mean literally thousands of people watching this particular case happening. This is of public interest. Everybody in the United States of America should be watching this case because our republic is on the line. We should not be determining our elections through judges and on the judicial branch using the bench, the far left using the bench to control the outcomes of what the future of all of us Americans are going to be like. That is what our legislative branch is for. That's why we hold elections. That's why we cast our ballots. And they overwhelmingly, once again, in the Eastman District, voted him in as their representation for Alaska. And yet, here's a far-left fringe, Kowalke, and the group, just so we get a concept of who this person is, that they are involved with bringing us the ranked choice voting. They were involved in the vote no for the con. They were involved with everything that has been pushed on the extremist level. Every lawsuit that keeps being filed in court to help push the agenda of spend more, spend it faster, vilify anybody that does not agree with that. This is the type of person, and this is the person that is brought this case against David Eastman right now. Our republic is on the line, and I can't emphasize that enough. Our republic right now, the future of it is on the teetering wheel of the balance there, and good old Lady Justice is going, you know, I'm trying to weigh the scales out there so that we're all on the same even playing field. But this is kind of the way it goes right now. If you are one political spectrum that perchance has a D by your name, this is how the scales weigh out. Those that don't have a D by their name, they are being forced way up here because all of the effort to help those with the D are down here, and they're making sure the scales of justice are no longer applying when it comes to our judicial branch, our court system, and our republic that we live in right now. I am so happy in some ways that I am still snowed into my driveway. I have not been able to leave my house now for 2 days. My street has yet to be plowed. The last time I looked at it this morning, my driveway has still yet to be plowed. I am sitting with over 3 feet of brand new snowfall. I had someone come out yesterday and with a pickup truck to do some work here in my shop. And they literally, and they sit a good 6 inches higher off the ground than I do in my vehicle, and they were plowing through the snow and left literal tunnels from getting into my driveway. I drive a small SUV, suffice to say I can't do what they were able to do to get in and out of my driveway. And it is snowing right now. There's about another 2 inches that have hit the ground this morning, and it's continuing to come down as we speak. So I'm streaming this all to you via their stream that they have coming directly from the courthouse. And so there's an advantage to this. We're actually able to see the witnesses that are participating by Zoom. And majority of all the witnesses that they have that are going to be presenting in this case are all by Zoom. So the current witness, Lewis, who's going to be cross-examined by the defense here real soon, has taken the stand, and he has been giving his expert opinion about the extremist organizations out there. We're talking like the Boogaloo, they claim the Oath Keepers, the white supremacists, the white nationalists. You know, I can keep going right on down the list. Who did they not name? Antifa. They didn't name Black Lives Matter. Those folks have provided their own extremism within our country and our nation on a regular basis. The evidence is out there that they should be labeled as extremists themselves. President Trump tried his best to get that to happen. Antifa was labeled that. But you know, if you were to take the time right now to type into Google Antifa.com, guess where it takes you? Take a lucky guess. Any ideas? Come on now, I'm sure a few of you out there got an idea. Well, if you were to actually type that into Google search right now, it would take you to the White House's website. Yes, you heard that right. It would take you to the White House's website if you were to type in Antifa.com. During the presidential election, it took you to the Joe Biden donation page to contribute to their campaign. If you can't get no more blatant example of what is going on within our nation and the subversion that they are doing out there, why is it that these groups never show up or never active, or we never really hear them in the news until it's time for an election? Because that's when they get mobilized. That's when they push them out there to go out there and cause as much destruction as they possibly can, and then point the finger and say, look at those Republicans out there, look at what they're doing. Yet it's not the Republicans that are burning buildings down, federal buildings, churches, police stations, Molotov cocktails, fireworks, lasers, killing police officers. As far as I've been able to see, everything during the Summer of Love was not caused by the group that keeps being vilified. Those people are immediately, how you say, if they are arrested, are immediately released, and then absolutely no charges are placed against them. After that, they're dropped, or they get the lightest sentence you could possibly ever get. Yet, if you're on the other political spectrum and you show up like Kyle Rittenhouse trying to defend himself, you find yourself vilified and everything else. Or how about the Sandman doing nothing more than standing on the Capitol steps there, having that Native American beating his drum in his face and doing nothing there but smiling. In some ways, I kind of wish I was the Sandman, because I would be a multi-millionaire at this point. And if you think what I'm doing right now is great, you could only imagine the level that I would take it if I had the money to be able to afford to do that. And you guys can help me do that by supporting what I do. And here shortly, my website is currently down. I had to transfer service providers. I'm hoping to be moving into a new provider now that is 10 times faster. No longer having to click to go to my website and go get yourself a cup of coffee and come back, and it might be loaded at that point. I'm hoping to bring us into modern day technology, and you click on the link to go to our site and the page will immediately load right on up and you're moving right along. Once it is back up and running, which should happen before the end of this week is over with, go to Politadick.com and click our support button. Make a donation today. It's your support that has gotten me this far so far. It is your support that makes this broadcast possible. Instead of me being at work turning wrenches, I'm able to be here reporting the news that mainstream media and the extreme left don't want you to know. Alaska legislators are trying to keep us in the dark this year. It is very clear. It came out during the testimonies by their expert extremist witness there on the extremist groups that our Alaska legislators had a direct hand in bringing this lawsuit forward. I mean, why else would he name off Chris Tuck? And they would name off other legislators that are there that were involved in the beginning of all of this. There's a reason for it, and that's because they want all the power and all the control. We saw it directly after the elections. The elections hadn't even been certified yet, and out came the Senate declaring their supremacy over everything that is going to happen there, handed over full control over to the Democrats once again, even though we, the majority of Alaskans, vote in Republicans to be in power, not the Democrats. But what did they do? They handed it right over to the Democrat, appointed nearly the exact identical people to the Senate Finance Committee, who also happens to be in control of the entire budget for the state of Alaska. And they have the final say, plus the only say, what makes it into that budget. If you want things to change, we need to change out the players, or we need to put people that are in charge that are actually going to put people into those committees, the Senate Finance and the House Finance Committees, that work for Alaskans. And this is one of the reasons why this particular case is coming forward right now and why they're going after David Eastman. He is not what they say a play along to get along legislator. He works for us, the people. There's been only a couple times I've ever disagreed with his votes. One of them was, of course, as you all know, the budget last year, the concurrence vote that would have gave us a full statutory PFD. His no vote cost us being able to receive that, which put it into a special committee, which stripped all of that back out of there again. Well, this year we're looking at, if we're lucky, we might not even get a PFD. And I say if we're lucky. So if we're really lucky, we'll get to see a PFD, and it's only going to be about $500, maybe $1,000. I'm predicting $1,000, even though this year's PFD should be another record breaker, $4,000 PFD that comes out in the following year. This is the type of games that they play. This case right here is very pivotal on what is going to happen next. And it determines on where our Alaska's government and elections are going to head to in the future. We've got to work hard to expose what they don't want us to see. And the way we do that is we share videos like this one. It is so important. I went through leaps and hurdles to be able to get myself the press availability to be able to live stream this to you. I am, by the court system, authorized to be videoing, recording, and distributing this out to all of you. I am one of the few out there that actually has that ability. Our mainstream media applied for this type of coverage, yet where is their coverage? Do you see it? Do you see it on TV right now? Have you received any notifications from, say, Alaska News Source or KTOO that this case is going on right now? Tune in, watch it, participate. be a part of our republic, see which direction that our court system is trying to determine that it will go, and the level that the extreme left out there is willing to go to use our judicial branch to determine things. I'm really sad that we Alaskans didn't vote in the con, but it's hard to compete when you've got about $100,000 for the vote yes, and you've got $5 million for the vote no on that particular election. And where did all that money come from? Like 1630, NEA of Alaska. I could keep going on down the list of all the far left extremists that contributed to changing Alaskans' minds and telling them how they're supposed to vote. Our rural communities are the ones that are the most dangerous to look out for. Reason being is in our rural communities, they don't get nothing but PBS, NPR, and folks like that that are determining who or what we will get to see when things are going on out there. Looks like they're about ready to begin again. I'm going to go ahead and quit talking here so all of you guys and me can participate in the case that's going on. Don't forget, like, share. Don't worry, folks. They haven't gotten the audio up and running just yet. And so I'm watching. Oh, there it goes. I see their audio just kicked on. I'm going to silence mine, and away we go.
The introduction of those words. So anyway, I'm using that and cross. We'll see how it goes. 3 hours, Gordon? Yeah. Holy cow, man!
Yeah.
On the live stream.
She's very upset with me. Oh, so she would have been here with the children. You're in trouble. You're going to ask her first. Do you want to connect the dots? Yeah. You want me to ask Sally to bring the sandwiches? Better you than me. Okay. But does she not like you?
No.
I have just taken off when I say that we're on the overhead. Not everything about 45 seconds worth. When I said, hey, we've got parties on the overhead, we're live on the live stream. So I pulled them off so they don't have to listen through lunchtime. Well, luckily you didn't get caught on an open mic. Saying things you probably shouldn't, but I pulled them off the overhead to avoid that. Fortunately, it's quite the hike from Chambers to Portland. Wherever we are. Yes. 7. Rise to the Corporate State of Alaska, reconvene.
Seated, everybody. We're back on record with the parties present. Mr. Dedukian, you may continue.
Thank you, Your Honor. Mr. Lewis, can you still hear me okay?
Yes.
Before the break, I was talking to you about the guilty pleas and statements of offense that were filed. So before we go back into that, can you give us a summary of the individuals who were charged, what positions they had within the Oath Keepers organization?
Yes, I can. Several of them held high levels of Sorry, there was some feedback. Several, including Kelly Meggs, were either chapter heads of their state chapters. So Kelly Meggs, for example, was the head of the Florida chapter, while others like Jessica Watkins led their local willing members of the Oath Keepers chapter from Ohio, for example, to the Capitol on January 6th. And within these pleas, and namely the statements of offense, especially in this seditious conspiracy for Ulrich, James, and Mr. Wilson, you'll see that the statements of offense that these defendants agreed to makes clear that they conspired with Stewart Rhodes, that this was a top-down conspiracy where the founder and leader at the time, and still leader of the group, conspired with his co-defendants, gathered as many as he was able to the Capitol on January 6th.
And so the three who pled guilty or pleaded guilty to seditious conspiracy charges, those were Wilson, James, and Ulrich, is that correct?
Yes, sir.
And if you look, or do you know what position Wilson held in the Oath Keepers?
He was the county head of one of the North Carolina chapters of the Oath Keepers, and he served as one of the several individuals from North Carolina who was responsible for mobilizing significant numbers of North Carolina Oath Keepers who have not been charged to bust themselves up to the Capitol on January 6th.
All right, and what about Joshua James? Do we know his position within the organization?
We know he was a member of, I believe it was the Alabama chapter of the Oath Keepers. I do not believe the government has denoted how high in that local chapter he was, but he was the point of contact between Stewart Rhodes directly and members of the Oath Keepers in that region, both before and during January 6th.
Okay, and of all of the 33 individuals who were charged, were they all at least members of the Oath Keepers?
All 33 were members or affiliates of the Oath Keepers. I believe there was one individual, Thomas Caldwell, who was not a formal member of the group, but who joined the group and was part of their conspiracy prior to January 6th. So I do not believe he had formal membership, but for all other 32, it is my understanding that all were members of the Oath Keepers, yes.
Was Kelly Sorrell charged?
Yes, Kelly Sorrell was charged in 2022. Kelly Sorrell is the general counsel for the Oath Keepers, and she's been charged in relation to the group's activities on January 6th and her attempt to help them destroy evidence related to their criminal conduct on January 6th.
And what is the status of the case against Sorrell?
Her case is still pending.
Now, in your review of the statements of offense that were filed by the Oath Keepers who pleaded guilty, did you make a determination as to whether they were consistent with one another?
Yes, all three had near identical established overt acts with, of course, specific carve-outs for whatever individual actions took place. So, for example, Mr. Wilson, who pleaded guilty to seditious conspiracy, was side by side with Stewart Rhodes for much of the afternoon of January 6th. I believe he briefly left Mr. Rhodes' side to go into the Capitol for the purposes of conducting reconnaissance, and then returned to Mr. Rhodes' side as Mr. Rhodes made phone calls to his operations leader and to Kelly Meggs, who led the Oath Keepers up the Capitol steps and ultimately used force to breach the building. By contrast, for example, Brian Ulrich was part of Stack 2, who had been doing VIP security detail, who had temporarily left the rally area to return to a hotel, and then saw the TV, received messages from Oath Keepers, and then Stack 2 traveled to the Capitol, ultimately also breaching Capitol, the rotunda doors. And so the statements of offense are obviously, a little bit different in terms of the specific conduct of the defendants themselves, but all three of them paint a very homogenous picture, which is that each of the three conspired with each other, with Stewart Rhodes, to travel to the U.S. Capitol on January 6th with the intended purpose of preventing the peaceful transfer of presidential power on that day.
And Judge, if we could maybe have clarification of which all three he is talking about, because we had 5 different oath keepers that were described in that narrative.
Sorry. Mr. Lysias, can you please just clarify which three you're talking about?
Yes, I'm referring to the 3 oath keepers who have pleaded guilty to seditious conspiracy, which would be Brian Ulrich, Joshua James, and William Todd Wilson.
All right, now, before the break, and earlier in your testimony, you kind of distinguished between online and offline activities of the Oath Keepers. And so I want to start with the online activities starting around the time of the November 2020 presidential election.
Mm-hmm.
Can you tell us generally how the Oath Keepers responded online to the results of the election as they were coming in?
Sure. So by the election itself, the Oath Keepers had been taken off of Facebook and Twitter for repeated violations of their conduct policies. And so what was created by that point was that kind of echo chamber we had talked about previously, where they were steeped in this Stop the Steal conspiracy. So before the election is even decided, before the first in-person ballots are cast, Stewart Rhodes appears on Alex Jones's talk show, InfoWars, and discusses his fears that a civil war is already happening, that it's going to get worse, that 20,000 members of Antifa are going to storm the White House once Trump wins the election. He says that the Oath Keepers have undercover members who are stationed at polling stations watching out for voter fraud. And he warns that if a civil war is to come, that the Oath Keepers will engage in this fight, and that they will target the command and control of their enemies when that inevitable conflict takes place. And this was, again, all done before a single result was announced.
So a couple things. One, about this echo chamber that you mentioned, if the Oath Keepers by November 2020 were not on Facebook and Twitter anymore, how were they getting their message out?
So a couple of different ways. So they were using other social media platforms, but namely, and most relevant here, you saw public pronouncements by Stewart Rhodes, mostly using the Oath Keepers website, which at the time was still active and has since gone offline. But using the national Oath Keepers website, Stewart Rhodes pushed out multiple open letters to President Trump, national calls to action to conceivably every member of the Oath Keepers in an attempt to, continue this narrative that the election either will be stolen or it has been stolen, and try and center the kind of fixation of the group on a target, on an enemy. And as November goes into December, as these public statements by Rhodes continue, they're mirrored by private messages, namely on Signal, an encrypted messaging application that, in the days after the election, Rhodes began using to create groups, namely, with his leadership cadre and with specific local and regional chapters of the Oath Keepers in order to begin preparing them for this operation on January 6th in DC.
Now, before we get into the private communications, I want to speak more about the public communications. Was Rhodes making any statements to journalists or appearing on podcasts?
Yes, the Alex Jones InfoWars show is the most obvious example of that. That was on October 27th, 2020. On that, he really sketched out for the first time what would be a consistent theme, which would be that the election's going to be stolen, that the Oath Keepers have to be prepared to fight, and that President Trump has to invoke the Insurrection Act. And again, just preparing his followers for this inevitable civil war and this conflict that he knew would take place.
And since you mentioned the Insurrection Act, can you tell us what the significance of that act was to Rhodes and the Oath Keepers?
Absolutely. So in the eyes of the Oath Keepers, they saw the Insurrection Act as one of a number of tools that they hoped that President Trump would leverage in this period before and especially after the election. In their eyes, they saw the Insurrection Act, which again is a federal mechanism which would allow the president to unilaterally call up military and National Guard forces for domestic use, which effectively annulling temporarily the posse comitatus statute. In the conspiratorial mind of Stuart Rhodes and the Oath Keepers, this Insurrection Act would serve a couple purposes. First, it would allow President Trump to use the military to seize voting records and voting machines from across the country. It would allow him to call for the declassification by the NSA and CIA and other government agencies of this apparent trove of evidence that the agencies have been sitting on, to flush out the deep state in Stuart Rhodes's mind. And namely, especially as it relates to the Oath Keepers, Stuart Rhodes and the Oath Keepers saw the Insurrection Act invocation as a mechanism through which they could claim that they had been called up, that they were truly becoming this militia that they had long imagined that they actually were. Again, it's important just to make clear that there is no foundational basis for this, illegal ad hoc militia to gain legitimate status. The Oath Keepers are not part of the U.S. military. They are not part of the National Guard. No aspect of the Insurrection Act would magically allow the Oath Keepers to somehow unilaterally engage in whatever conduct they were hoping to engage in. But what you saw was this consistent theme by Stuart Rhodes telling his supporters the Insurrection Act will be invoked. And
can you hold on 1 second?
Mr. Lewis, can you hold on 1 second? We have an objection.
In Your Honor, you may be able to anticipate this objection. I mean, it does relate in part to some of the briefing before, but this witness has already stated under oath in his deposition that he's not a legal expert, and yet he's offering a legal opinion. And so I'd object on that basis to the testimony relating to whether or not there was a legal basis to utilize the Oath Keepers in any type of militia fashion by the president.
I'll take the testimony. I understand the objection. I'll take the testimony for the purpose of explaining his opinion, but not for an explanation of what the Insurrection Act actually means. That's, Mr. Miller, you're correct. That's the court's function to make that determination. So for that purpose, though, I will hear the testimony.
Understood. And so, Mr. Lewis, do you remember where you were in your answer?
Yes. Effectively, Stuart Rhodes had publicly asserted that the Insurrection Act would allow the Oath Keepers to engage in the necessary conduct that they wanted to engage in. He viewed the Insurrection Act as a lever through which to make their conduct permissible, to give the legal or political cover for the Oath Keepers to engage in their conduct on January 6th.
And again, before we get into some of the specific communications, as a general matter, did the Oath Keepers have a plan B if the Insurrection Act was not invoked?
Yes, the Rhodes and the Oath Keepers, both in private and public communications, many times stated that their hope was that the Insurrection Act would be invoked. However, it was made clear both in the November 9 go-to meeting and in subsequent public and private communications that Rhodes was preparing his group to use violence, to use force as needed, one way or the other, to prevent the peaceful transfer of presidential power. Again, it was their hope that the Insurrection Act would give them that cover that they were looking for, but the plan B, as they lay out quite clearly, was that they would act first and ask questions later, effectively.
And in addition to the interviews and statements posted on the website, were the Oath Keepers also communicating with membership during this time period?
Yes, there was at least one notable email that was sent out on November 3rd to all members, which again carried on that the train of argument that Rhodes began in that October 27 interview, which was calling the election fraudulent, saying that there would be widespread voter fraud, telling his supporters to be ready, to be prepared, to take the action they had to do to stop the steal.
And sir, if you can turn to Exhibit 6.
Yes.
And if you would note at the bottom, there's a base number that starts with DCE. And I will represent that this is a document that was turned over to us in discovery by Representative Eastman. Have you seen this document before?
Yes.
And can you tell us what this document is?
Yes, this is a November 3rd email from the main info@Infowars email address. Again, the national central email address for the Oath Keepers entity to the mailing list of the Oath Keepers titled Oath Keepers Critical Message to Patriots on Election Day and After.
And if you look at the from at the very top of the email, where does it state that the email was sent from?
It was sent from Oath Keepers Stuart Rhodes.
And this particular email, who was it sent to?
It was sent to david.eastman@gmail.com.
And is it your understanding that the same email was sent to the entire membership of the Oath Keepers?
Yes.
And does this email encapsulate the mentality of the Oath Keepers? Well, let me back up. What is the date of the email?
The date of the email is November 3rd, 2020, right before 1 p.m. Eastern Standard Time.
And what else happened on November 3, 2020?
This was the beginning of the election process itself.
Okay, that was the election day, right?
Yes.
And does the email that was sent on election day encapsulate the mentality of the organization going into the election?
It does. Yes. It reflects that there was this widespread belief propagated by Stuart Rhodes throughout his organization of like-minded individuals that the left, that Antifa, that BLM was preparing to conspire with the Chinese Communist Party, with George Soros, with members of the deep state to steal the election. And it mirrors many of the themes laid out both before and after this date by Stuart Rhodes, as well as many other individuals who have subscribed to the Stop the Steal conspiracy.
Did the email get into any of the Stop the Steal issues?
Yes, several of the prominent points that the Stop the Steal conspiracy hinged on are reiterated here by Stuart Rhodes in this national email to Oath Keepers members.
And was it the expectation of the Oath Keepers or Rhodes that there was going to be massive vote fraud even before the election?
Yes, there was.
And what did this email say was the significance of the election to the future of the United States? Let me strike that and start over. What did the email say about the significance of the email to the future of the country?
Yeah, in the email, it makes clear, Stuart Rhodes makes clear that this election will decide the fate of the country, and it's incumbent on every Oath Keeper to be ready, to be watchful, to expect there to be voter fraud, and to expect there to subsequently be civil unrest as a result of this perceived, imagined, attempted fraud in the election.
I want to turn now to some of the statements that were posted on the Oath Keepers website. Can you turn to Exhibit 18?
Yes.
Do you recognize Exhibit 18?
I do, yes.
What is it?
This is the first of two open letters that were published on the main Oath Keepers website, authored by Stuart Rhodes, and which were directed at President Trump.
And what was the date this first letter was published?
This was published to the Oath Keepers website by Stuart Rhodes on December 14, 2020.
And when you say Oath Keepers website, do you know what the web address was for that site?
It was https://oathkeepers.org.
Is that site still active?
It is not at this moment.
So how did you get a copy of the letter?
This letter was made available by the Wayback Machine, which captured the contents of the Oath Keepers website accurately on that date.
And have you been able to corroborate or confirm that the letter we're looking at in Exhibit 18 is the same as the letter that was published in December of 2020?
I have, yes.
And how were you able to do that?
Several ways, namely conferring with other subject matter experts, as well as reviewing the contents of the letter in comparison with evidence presented by the U.S. government in these ongoing trials, which make clear in terms of both the timing, the content, and quotes from the letter that this was the letter itself, along with both contemporaneous reporting from when the letter was actually released, as well as reporting which detailed the letter in sum after it was published.
And how was the rhetoric in the letter, how did it compare to statements by Rhodes both before and after the letter was posted?
It aligns almost identically to the major talking points that we saw Rhodes present before the election, as well as on the eve of the election. It calls on President Trump to invoke the Insurrection Act. It warns him of the dangers of, I believe the phrase was Chinese communist puppets or Chi-Com puppets, and tells him that he must take decisive action, including what we referenced earlier regarding mass declassifications, the use of the military to investigate these believed assertions of voter fraud in order to save the election and save the country, in his view.
Was the letter signed?
I believe it was signed by Stuart Rhodes, yes. And Kelly Sorrell, the general counsel of the Oath Keepers, who was later indicted.
And so can you generally summarize for the court what Stuart Rhodes and the Oath Keepers' game plan was as stated in this letter?
As stated in the letter, the game plan was for President Trump to invoke the Insurrection Act, to mobilize the military and National Guard in order to take the voting records, to free Julian Assange, to place him in charge of this declassification effort, and to investigate the myriad efforts that Rhodes and his followers believed had contributed to the results of the election. And in his mind, this had to be done as soon as possible, while President Trump was still the commander-in-chief.
And you've mentioned declassification efforts a few times, so can you elaborate what you mean by that, or what Rhodes meant by that? Yes,
absolutely. So in the, again, conspiratorial thinking of not just Stuart Rhodes, but many who had embraced this Stop the Steal conspiracy, there were actors inside the deep state at the national security, inside the national security apparatus of the United States who were working against President Trump, who knew of voter fraud or knew of foreign interference by Russia or China or Iran, and who were hiding it for purposes of aiding the George Soros-backed globalists and the global elite. And so, as the letter details pretty clearly, Rhodes believed that all these activities were needed in order to fight back against this deep state, fight back and prevent, President Biden from coming into power. Because again, according to Stuart Rhodes, the election was stolen, and this was the only way forward to maintain the rightful pathway that he saw ahead of him.
How did the letter characterize the incoming administration?
It characterized President-elect Biden and Vice President-elect Harris as Chi-Com puppets, as puppets of the global elite, and warned that these individuals would use force, would use power against him, against his family, against his political supporters, if he did not take this action expeditiously.
And that term Chi-Com puppet, is that a term that was used by the Oath Keepers at the time?
Yes, it became a relatively standard phrase, both by Rhodes, Oath Keepers, and other Stop the Steal proponents who had some belief that the election was only won because of some unnamed, unspecified interference by China, who had some control over President-elect Biden.
Did the letter say what would happen if President Trump failed to act as suggested by Rhodes?
Yes, in this letter and in several others, it's made clear that Rhodes believed that the Oath Keepers would be forced to take action if these steps were not undertaken. Because again, in their mind, they were trying to position themselves as the only individuals left who could be called upon to prevent this from taking place. And so in both this letter and in other public pronouncements by Rhodes, he warns of this impending bloody fight that would take place that the Oath Keepers were willing to engage in order to achieve these goals.
And just very briefly, I want to just strike that. Let me ask you about something else first. Was there a second letter that was published on the Oath Keepers website?
Yes, there was a letter that was very similarly focused that Stuart Rhodes published to the same website with the same content generally on December 23rd, 2020.
And is that second letter the one at Exhibit 19?
Yes, it is.
And did you obtain the December 23 letter in the same way that you obtained the December 14 letter?
I did, yes.
And who signed the December 23 letter?
This was also signed, I believe, by Stuart Rhodes and Kelly Sorrell.
And as far as content, did it add anything to the December 14 letter, or did it repeat the same themes?
It was almost identical in terms of the tone, the content, the repeated calls and need for action. What it did begin to start crystallizing, if you look later down in the letter, is that January 6th date, which really came into play after President Trump tweeted out the "Be There Will Be Wild" tweet. That really crystallized a lot of these groups, like the Oath Keepers, around January 6th as their last chance to act. Right, that hard constitutional deadline. In the eyes of the Oath Keepers, that was their last chance to actually take this action that they had been looking for an opportunity to take, and they saw January 6th as the opportunity to do so.
Is that the first instance that you're aware of where the January 6th date crystallized in a public statement issued by the Oath Keepers?
Yes, the concept of the certification of the election had been referenced several times previously, but this set of letters was the first time you see that date coming into play as the kind of focal point. Some of the private messages by Rhodes was planning for a DC operation. They had gone to the district on December 12th. Some of them had. So this was really crystallizing January 6th as the date in which they could really, execute their plans.
And again, we're going to get into those private messages in a second, but if I can have you turn to Exhibit 14.
Yes.
Have you seen that document before?
I have, yes.
And can you describe what it is?
Yes, this is an email from Oath Keepers, the OK support at oathkeepers.org to David Eastman, david.eastman@gmail.com. Is the national call to action. Oath Keepers deploying to DC to protect events, speakers, and attendees on January 5 and 6. Time to stand.
The OK support at oathkeepers.org address, to your knowledge, is that an address that the Oath Keepers would use to communicate with membership?
Yes.
And this particular email was sent, among other people, to David Eastman, right?
Yes, sir.
And did this email call to action reference the two open letters that the Oath Keepers had posted on their website?
Yes, it tells the Oath Keepers who are reading this email. It provides links to the two letters and tells them to go read the two open letters to President Trump. Yes, sir.
And the titles of the open letters, as stated in this email call to action, did they correspond with the titles of the letters in Exhibits 18 and 19 that we talked about?
Yes, they do.
Your Honor, I would move for the admission of Exhibits 18 and 19.
Same objection as the continuing objection, hearsay on top of it.
Your Honor, it's a slightly different response, but generally the same theme. The letters should come in at a minimum as support for the expert's opinion under. But in this particular case, the letters aren't hearsay because they're not being offered for the truth. They're being offered not for the truth of anything that was stated in the letters, because nothing true was really stated in the letters. They're being offered for the purpose of showing that the statements were made. So it's in the same vein as a defamatory statement or any statement that has independent legal significance. It's not hearsay.
I will let them in both as, well, Ms. Burley, do you have a response to the second?
I was just going to say, again, Judge, they're actually trying to get these exhibits submitted for factual purposes as opposed to the reliance their expert has made on them. With respect to the latter, consistent with your earlier ruling, if that's how the court is considering them and then reserving on the independent factual significance of the letters, then I'm not going to say no objection, but I certainly understand that approach.
I will take a different approach in this one, and the reason is that you find that they're not hearsay, and so as far as that objection, it's overruled because they're not admitted for the truth of the matter asserted in, but for the fact that the statements were made. There was sufficient authentication, I find, that these two letters, at least in it's 18 and 19, were what they purport to be by the plaintiff, and that therefore there's a non-hearsay purpose, so they're admitted into evidence for that.
One last thing, Mr. Lewis, before we shift gears, but was there also a statement made by Rhodes at the Jericho March?
Yes. Stuart Rhodes gave several minutes of public remarks at the Jericho March on December 12, 2020.
And can you just briefly describe what the Jericho March was?
Yes, it was a march run by this religious organization that was generally framed as opposition to the results of the 2020 election. Many of the speakers and VIPs of the Jericho March on December 12th were later VIPs and speakers at the January 6th rally. And the general content of the speakers' presentations on that day surrounded the need for action to prevent the illegitimate, or in their minds, of course, illegitimate Biden administration from taking power, and that the time for action was now, and that January 6th was this moment for action, that everyone should return on January 6th. And of course, in Rhodes's comments, he articulated once again the need for President Trump to invoke the Insurrection Act, and warned that if he did not, the Oath Keepers would be forced into taking this, action in furtherance of this bloody conflict.
Where was the Jericho March held?
In the District of Columbia.
And you mentioned some of the same speakers were at the Jericho March as the January 6th rally. Do you know if John Eastman was a speaker at either of the rallies or marches?
I know he was a speaker.
Mr. Lewis, hold on one second. So what's the objection?
Objection relevancy.
What's the theory of relevance?
Well, John Eastman is going to be one of the witnesses, experts called by the defense, and so if he was present at these rallies, I think it's relevant to inform, the credibility of his opinions.
I'll hear the answer to it and give it the weight I find due.
I'm aware that John Eastman was a speaker at the January 6th rally, in which he called on Vice President Pence to reject the lawfully selected group of electors that have been put before Congress. On my recollection today, I cannot recall if he was also a speaker at the Jericho March on December 12th.
And Your Honor, at this time we have a short video clip of a statement made by Rhodes at the Jericho March, but I'm not sure the best way to play it.
What's the exhibit marked as?
It's 45. It's not in the binder because it's a digital file. We have it on a thumb drive that I can give the court. I emailed copies of it to counsel.
Unfortunately, we have an issue with putting thumb drives directly, and it's something we need to process through IT. So we wouldn't be able to put it into our computers until that's been submitted. What else do we have? Screen share? Would you like perhaps a screen share, understanding that there might be objections still?
A screen share from my computer?
Via the Zoom, maybe a screen share would be best.
Perhaps we can do it after the break.
Sure.
I'll go back to it. Mr. Lewis, at some point after the November 2020 election, did the Oath Keepers start preparing for actions?
Yes, they did.
And when did these preparations start?
Right around Election Day is when Rhodes began creating specific Signal chat groups. So the primary one that's of relevance here would be the leadership chat that was referenced. This comprised of Kelly Meggs, who was later charged, as well as numerous other prominent members of the Oath Keepers who were later charged in relation to January 6th. And the purpose of this chat was for Stewart Rhodes to begin dictating his operational plans to the leadership cadre, with the intent that be then passed down to state and local chapters to ultimately lead to mobilization. And so you had communication between Rhodes and his team leaders, including Kelly Meggs and Michael Simmons, or Michael Green, who was later also indicted and charged with conspiring to obstruct an official proceeding. And you also had secondary lines of communication between, also in Signal chats, where Stewart Rhodes, for example, would communicate with the Oath Keepers of Georgia Signal chat and directly relay his plans and his communications for what he wanted from the Oath Keepers on January 6th. And the rhetoric, the content, the narratives were all the same throughout, which is that the Oath Keepers had to step in, they had to fight, they had to take action on January 6th, and they had to come to the Capitol with the intention that there would be the need for them to engage in force to prevent the peaceful transfer of presidential power.
Okay, so I want to have you explain some of the different components of your answer. First of all, can you explain what Signal is and how it was used by the Oath Keepers?
Yes, so it's an encrypted messaging application that offers end-to-end encryption between the participants of a direct message. And so you could either have a one-on-one conversation with a specific contact. You can also create group chats with, I think up to 100 or 200 members. And that would, again, offer the same end-to-end encryption for both users and would allow a stable, functional messaging application, similar to a text group chat.
And when you set up a group chat on Signal, are the participants by invitation only?
Yes, you would add a group of your contacts, for example. It is not something you can. I could not just stumble upon a group chat that you had created. It is a closed, secure, encrypted chat room, effectively, that the owner of the chat room and participants can invite other individuals or pull other individuals into.
And you testified that one group chat was set up for the leadership cadre. Can you tell us who was included in that leadership group?
Yes, among others, there was Stuart Rhodes, again, the founder leader of the Oath Keepers. There was Kelly Meggs, who was the leader of the Florida chapter. There was Kenneth Harrelson and Thomas Caldwell, to my recollection, who were both later charged as co-defendants to Stuart Rhodes in the seditious conspiracy case. There were also individuals such as Donald Seekerman, who was originally the operations leader for the ground team for the Oath Keepers on January 6th, but who was not charged. And there was also Michael Simmons, who ended up becoming the operations leader and who was subsequently charged. And to the best of my recollection, William Wilson was also part of that leadership intel chat.
And earlier you said Michael Green or Michael Simmons. Are those two names for the same person?
Yeah, yes. Both names have been used. I believe he was originally referred to in public record as Michael Simmons, but the charging documents for him, I believe, to the best of my recollection, referred to him as Michael Green. But it is the same individual. I believe his call sign was Whip, and he was the individual who was named by Stuart Rhodes as the ground operations leader for January 6th, and who, along with William Wilson, was physically present with Rhodes on Capitol grounds for the duration, or the bulk at least, of the afternoon of January 6th.
So on January 6th, was he the operations leader?
Yes, he was.
And did he appoint himself operations leader, or was he designated by someone?
He was designated by Stuart Rhodes. After, I believe, Donald Seekerman, to the best of my recollection, fell ill or was otherwise unable to make the trip to DC, and in his stead, Michael Green, who was already planning on traveling, was appointed as Rhodes's number 2, the operations leader on that day.
And other than the Signal chat group for the leadership group, were other Signal chats set up for example, the regional or county level operations?
Yes, based on evidence that's been set forth publicly, there were Signal chats for the Georgia chapter of the Oath Keepers, the North Carolina chapter of the Oath Keepers, and the Florida chapter of the Oath Keepers, each centered around those specific regional groups or county level groups' participation in the events of January 6th. And they were used both for example, for Kelly Meggs, who was the head of the Florida chapter, to pass on direct messages from Stuart Rhodes to inform his subordinate Oath Keepers of what the plans were, and also to engage in planning, including operational training, firearms training. I believe at one point in December, they'd engaged in a tactical exercise, which involved, setting up a roadblock and other close quarters tactical training. But yes, these signal chats were all used by Oath Keepers, co-defendants, and uncharged, unindicted co-conspirators who were all preparing for the eventual travel by these individuals to the U.S. Capitol on January 6th for the purpose of, again, preventing the certification of the electoral vote and preventing the peaceful transfer of presidential power.
And was the substance of some of these private chats later included in the statements of offense filed by the Oath Keepers who pleaded guilty?
Yes, the sections of many of these chats were included that detailed relevant aspects of those conversations. Yes.
And did you review, in your work on this case, did you review those portions of the statements of offense that discuss the encrypted chats?
I did, yes.
So if you can turn to, well, before you do that, as a general matter, was the substance of the encrypted chats different or consistent with the public statements of the group?
The content was consistent in terms of the single-minded focus of the Oath Keepers, right? It was clear that the narratives, the rhetoric, and the tone carried the same messages that Stewart Rhodes was expressing publicly. What I think is different and what I think is important to make clear is in public, Stewart Rhodes was making very vague statements around, we will be forced to act, the Insurrection Act has to be taken, while in private, they already recognized and they already were acting on the accepted premise that they would need to use force because they didn't think President Trump would take the action they were asking him to take. And so in their minds, it was really a foregone conclusion that we have to go to the Capitol on January 6th. We have to stop the steal. The only way to stop the steal is through the use of force or the threat of use of force against the U.S. government to prevent this transfer of presidential power. And so the content of the messages, the offline activities by members of the group in the buildup to January 6th were all consistent and were all with that intent in mind.
If you can turn to Exhibit 23, Paragraph 7.
Yes.
Is that paragraph in the statement of offense filed by Mr. Wilson, does that describe one of these private chats from Rhodes?
It does, yes. It describes the leadership chat that I discussed just a minute ago, which is colloquially described by the U.S. government in these filings as the leadership intel chat, which was the main leadership chat used by Stewart Rhodes to communicate with his lieutenants and other prominent Oath Keepers in the buildup to January 6th.
And so what was the date of that specific chat?
I believe they listed the start date of that chat as early November 2020, and the paragraph 7 that's referenced there shows a communication date of November 5th, which, as that paragraph notes, is 2 days after the presidential election.
And what did Rhodes say in that chat?
As that paragraph notes there, he urged the members of that leadership intel chat to reject the presidential election result and stated, and I quote here from paragraph 7, "We aren't getting through this."
Hold on just one second.
I just want to make sure the record's clear that, and again, you granted us a continuing objection. I think it covers this, but obviously this is hearsay. We object to it on that basis, and I'm sure we're going to hear a lot more about this or these type of statements from this witness going forward. If you could just grant me a continuing objection on that basis, if we haven't already.
I think I already have, and so my understanding or my recollection of my ruling was that I admitted 22 through 39 as documents that were reasonably relied upon by the expert informing his opinion. However, I have not ruled on your objection that I think is still continuing, that these are otherwise hearsay statements, that there's not another exception or reason for them to come in. That's a decision I haven't made yet. So I understand your objection is continuing, and I'm reserving.
Sorry to interrupt, Judge.
No, you're making your record. That's fine. I appreciate it. Mr. Dedukian, you may continue.
Thank you. So, Mr. Lewis, what did Rhodes say in this particular chat?
Yes. He said, and I quote, "We aren't getting through this without a civil war. Too late for that. Prepare your mind, body, and spirit."
And then if you go to Exhibit 25 at paragraph 8, and I'm just going to do these in chronological order, so there's going to be a bit of jumping around here.
Yes.
Is this another example of one of the substance of one of these private chats?
It is, yes. It communicates the expectation by Stuart Rhodes that there will be, quote, "a bloody and desperate fight. We're going to have a fight that can't be avoided," quote. That makes very clear the expectation by Rhodes that the use of force against the U.S. government is inevitable, that it's impending, that the Oath Keepers must take action prior to January 6th, because if they fail to take action and President-elect Biden assumes the presidency, that this conflict that he is envisioning will come to pass.
And then going to Exhibit 27 at paragraph 11A.
Yes.
That's another example of a private chat from Rhodes.
Yes, this is the Rhodes message to that Oath Keepers of Georgia chat that I referenced previously. And he is again discussing, quote, a quote, bloody revolution / civil war to defeat the traitors, quote, if President Biden were to be elected president of the United States.
And then finally, going back to Exhibit 23 at paragraph 15.
Mm-hmm.
Is this yet another example of a private chat that Rhodes sent?
Yes, this is on a December 31st message, again, to that leadership intel chat, which are the kind of core lieutenants. And this is Rhodes saying, quote, "There is no standard political or legal way out of this," quote.
So at some point, was there a virtual meeting held with the membership at large to start planning for January 6th?
Yes, there was a November 9th meeting that was held on a virtual video conferencing platform, GoToMeeting, that was attended by numerous Oath Keepers and which was run by Stuart Rhodes and General Counsel Kelly Sorrell.
Do you know what the Oath Keepers called that meeting?
I would have to refresh my recollection on the exact title of the meeting itself, if that's possible.
Sure. If you can go to Exhibit 23, paragraph 8. Does that refresh your recollection?
Yes. It was the Oath Keepers National Call members only was the title of the meeting that Rhodes ran.
And was that meeting recorded by someone?
Yes. It was recorded by an individual named Abdullah Rashid.
Who was Rashid?
Abdullah Rashid was an Oath Keepers member who had been invited to attend this national call meeting on November 9th. In his participation in the meeting, as was introduced in the federal trial of Stuart Rhodes, Mr. Rashid became concerned, reportedly, with the content of the comments that were being made by Stuart Rhodes, and decided that this information needed to be passed on to law enforcement because it was an impending threat of violence against the government.
And did Rashid subsequently testify in the trial of Rhodes?
He did, yes.
And did he, well, strike that, was it, can you look at Exhibit 21?
Yes.
Was the transcript of the meeting at some point filed with the court in the criminal case against Stewart Rhodes?
Yes, according to this exhibit, which is an accurate reflection of the transcript itself, this was filed in April 2018. I believe it was even filed by one of the defendants, Edward Vallejo, in an attempt to secure his pretrial release, if I'm not mistaken. And so this exhibit is a full recorded transcript of the November 9th go-to meeting run by Stewart Rhodes.
And was it subsequently admitted into evidence in the criminal proceeding against Rhodes at his trial?
I believe it was, yes.
Did you rely on the transcript in formulating your opinions in this case?
Yes, I did.
Before we get into the specifics of what was discussed at the meeting, can you give us an overall summary of what was discussed?
Yes, it again aligned very consistently with the contemporaneous comments by Rhodes and by others in the Oath Keepers at this point in time. It says that Rhodes believes that President Trump should declassify everything, that he should invoke the Insurrection Act, and that there is an urgent need for the Oath Keepers to take action to prevent the theft of the election.
How did Rhodes portray the urgency of the moment?
In his assessment of this timeline, he viewed that, again, the election had been decided, it had been stolen, the Oath Keepers had to act now, had to act urgently, that President Trump had to take immediate action while he was still commander-in-chief, and that this process needed to begin now because, again, in similar tone as some of his other statements we've reviewed here, he believed that if this action did not take place immediately, that President Trump would be removed from office in accordance with the lawful democratic process, that President-elect Biden would come into power, and that the Oath Keepers would then be forced to engage in that violent opposition to the federal government.
If you can turn to page 2 of the transcript at line 3.
Yes.
Where he says there's no such thing as another election in this country of any meaningful sense and term if you let this stand. First of all, when he says let this stand, what was he talking about?
The results of the 2020 presidential election and the perceived fraud that Stewart Rhodes and the Oath Keepers believe took place in the election itself.
And does this statement kind of encapsulate the existential threat that he felt to the country?
Yes, it does. He viewed this as a tipping point, a point of no return. He was convinced, as this transcript and his comments within it show, he was convinced that if the Oath Keepers did not act, especially if President Trump did not act, that the country would fall into that civil war that we've been discussing here.
And did he propose any plans during this meeting as far as what the Oath Keepers should do?
Yes, he made several general assessments that were later refined over the course of his public and private communications prior to January 6th. But in this meeting, he begins to kind of illustrate the broad parameters for what this opposition to the certification should look like. The need to oppose Congress, to begin to prepare at the state and local level, as we saw with several of the open letters, this need to keep your powder dry, and to if you're an Oath Keeper, to be prepared to take action against your enemies, against the government in this moment.
Did Rhodes anticipate that there was going to be a fight?
Yes, Rhodes was quite clear both in this transcript and before and after that there would be violence. Again, as his public comments illustrated, he had kind of created the idea that these Antifa super soldiers would be a significant part of this fight, but in that same breath, he was expecting that President-elect Biden and Harris would begin to illegally target American citizens with, SWAT teams and, raid towns across America looking for individuals who adhere to different belief systems and different values if they were to come into power. And so he very much viewed this as an existential threat to the Oath Keepers and to the militia movement as a whole.
If you can turn to page 11 of the transcript at line 4.
Yep.
Is this one example of where Rhodes anticipated a fight at this meeting on November 9?
Yes, where he says here, and I quote, "We're not getting out of this without a fight. There's going to be a fight, but let's just do it smart, and let's do it while President Trump is still commander-in-chief, and let's try to get him to do his duty and step up and do it."
At the same time, did Rhodes recognize that Trump might not do his, quote, duty?
Yes, I believe both in this transcript and elsewhere, he was talking out of two sides of his mouth at the same time, right? So he was calling on President Trump to declassify, to invoke the Insurrection Act, to declare martial law effectively, to allow him to stay in power, while on the other hand, simultaneously telling his supporters, I have called on President Trump to act. I don't believe he actually will. So we must be prepared to fight one way or the other to achieve the outcome we want here.
And so if you can turn to page 15 of the transcript at line 17.
Mm-hmm.
What did Rhodes say at this point about what would happen if Trump didn't do his duty?
Yeah, so, and again, quoting here, we call on him, the president, to do what needs to be done to save our country. And if you don't, guys, you're going to be in a bloody, bloody civil war and a bloody, you can call it an insurrection or you can call it a guerrilla fight.
Now, there's some other parts of this transcript that I was hoping you can explain for us. Starting on page 2, lines 21 and 22.
Yes. So here, beginning with the quote, so the only way to really stop them is for Trump to refuse to concede. And then the second thing he's got to do is he has got to use his authority as commander-in-chief to do critical things. And then it goes on to describe what we've discussed here throughout, which is the declassification of these alleged dirty secrets and a massive, quote, data belt. And so here, I think a couple of things are worth pointing out. The first is, again, that Rhodes and the Oath Keepers were attempting to use this shroud of legal behavior and constitutional activity in their eyes by President Trump, saying that he has to use his authority as commander-in-chief, while, again, in that same breath, saying that Trump has to refuse to concede, which openly goes against the core norms of the democratic process. And again, carrying on from previous comments by Rhodes, was telling Trump to declassify these purported secrets and use his power to seize all of this alleged data on voter fraud.
So when he talks about dirty, quote, dirty secrets, and then on the next page, he talks about at line 16, pedophiles who's in the Congress, and then another one, put the videos online and let the people watch them, and then at line 20, discloses the first handful of pedophiles who are in office. What was he talking about at that In the transcript.
And Judge, I mean, it's already on the record that I'm objecting to counsel testifying, basically reading through the transcript. He can certainly refer to the witness to the items of the transcript that he wants to testify to.
The objections overruled. He's asking a question about what do the terms in here mean, and that's relevant testimony for the witness to provide. Mr. List, you can answer the question.
Thank you. So in the references to pedophilia are important here because they demonstrate not just Rhodes's commitment to engaging in this kind of thinking, but also his embrace of conspiracy theories related to QAnon, which has been described by the U.S. government as a national security threat, and which was one of the several significant drivers as an extremism expert that I would say led to the events of January 6th. This idea that, there are pedophiles in the government, that there is this deep state, that there are Jewish puppet masters controlling the strings, and that, George Soros and his, globalist cadre are, somehow running a pedophilia ring from inside the halls of Congress. This does a couple things here. First, it shows again the embrace of Rhodes's, how deep Rhodes had gone into those conspiracies and how he had dragged his organization, of willing followers with him. And also it begins even here to crystallize Congress as the enemy. So as we've discussed here in relation to the activities of the Oath Keepers, when they get to the U.S. Capitol on January 6th, the target of their force, of their attempted overthrow of the U.S. government is the U.S. Congress, right? Is one of the three co-equal branches of power here. He's not saying that, there are pedophiles in the executive branch and the White House. That he's not saying that President Trump employs pedophiles and we have to go root them out. He's saying Congress. He's saying Congress, whose duty it is on January 6th to certify the results of the electoral vote, are run by pedophiles, that there's a pedophilia ring and that President Trump has to do his duty to root them out.
If you can turn to page 10 of the transcript, and starting on line 7, the first couple of sentences, what was Rhodes discussing at that point?
Yes, he is discussing a QRF, which is also a shorthand term for a quick reaction force. And so this was a small group that would be prepared to act almost as a response team in the event that, in his words, either here or elsewhere, shit hits the fan, right? So in the event that civil unrest takes place, in the event that the situation on January 6th escalates, that there would be a quick reaction force here. And again, in the transcript, I believe it's transcribed as QR rep, but it's QRF for quick reaction force, which we saw the Oath Keepers later use on January 6th in the DC Capital region, where you had a group of, I believe, 5 individuals who stayed in a hotel in Boston, Virginia, with all the firearms that the Oath Keepers had brought to the DC Capital region, which they did not bring into the district due to the district's gun laws and fear of arrest if they had open carried, and who this QRF was stationed in Boston, Virginia at this hotel with the expectation that if needed, they would be called in to ferry these weapons into the district to arm the Oath Keepers to fight against the government in this moment.
Was there a discussion of the locations where manpower would be deployed?
Yes, there's a discussion right in that section that you listed, where you would have a small available group of manpower of individuals, part of this QRF, with the bulk of the Oath Keepers comprising of the force, as he says on line 9 of that page, of who's going to be on the inside, who's going to be in the District of Columbia, who's willing to go without firearms. to be kind of like the first force in, awaiting support from that QRF.
Mr. Dudukian, we're getting close to a point where it probably makes sense to take another break. Are we near a natural stopping point in Mr. Lewis's testimony?
We are, but it's probably about 5 minutes away.
That's fine.
Should we keep going?
Yes, please.
Mr. Lewis, can you turn to page 17, line 11?
Yes.
There's a reference in that portion of the transcript of, quote, "It's going to be just like in Serbia." Do you understand what Rhodes was referring to in that section of the transcript?
Yes. There was a Texas-based individual, or a Texas-based Serbian by the name of Alexander Savic, S-A-V-I-C, who had given Rhodes advice and information related to events in Serbia 20 years before, where there was an uprising that overthrew the current government in power, which I believe was led by Slobodan Milosevic at the time. He provided this sort of step-by-step list of instructions of what must happen, right? The people must go out in the streets. You must occupy government buildings. You must, and there's a full, complete list of this step-by-step instructions that Rhodes shared both privately in that leadership intel chat and publicly to the main Oath Keepers website around this time.
If you can turn to page 16, line 14 of the transcript. Did Rhodes discuss during the meeting what the goal would be if President Trump did not invoke the Insurrection Act?
Yes. So as it's detailed here in that section of the transcript, he says that, quote, "The goal is to get to the point where you can eventually fight in the open, right? Conventional warfare to defeat the regime," quote. And then he goes on again to express the sentiment that half the military is on our side and that the president, once again, should do this data dump, expose the pedophiles and all the Chinese traitors, and that then that would secure the support for the Stop the Steal movement from the military. And his belief, as he lays out quite clearly there, is that would enable the Oath Keepers and their allies to have sufficient support to engage in open, conventional, warfare in the streets against the U.S. government.
Earlier, a few minutes ago, you testified about deploying manpower with some people outside D.C. and some people inside D.C. Did Rhodes talk about reconnaissance that the leaders of Oath Keepers had conducted before the meeting?
Yes, he does make a reference to that, and there are several references in private communications that show that members of the Oath Keepers, including, I believe, Thomas Caldwell, had traveled into the district with the purpose of conducting some form of reconnaissance of the U.S. Capitol area prior to this meeting. Yes.
So if you look at page 17, line 7, is that one example of where the reconnaissance was discussed?
Yes. And again here, I'll just quote, so we did a leaders recon. We went into DC, then we figured out where we wanted to stage on the outside. We got some preliminary routes figured out. And then later he references once again, it's going to be just like in Serbia. And so what you have here again is this kind of composite of information where Rhodes is making very clear, very direct references to an uprising of the people in Serbia that led to the overthrow of that government, with what he envisions taking place in the District of Columbia by the Oath Keepers and their supporters and their allies in these moments to target the Congress of the United States in an attempt to overthrow the U.S. government.
And finally, Mr. Lewis, if you look at page 18 at the bottom, starting on line 18, did Rhodes tell the participants in the meeting what gear they should take with them to Washington?
Yes, and he says here, and I quote, wear yourself some gloves, wear a cup, wear a helmet, get ready to fight. If you've got stab-proof body armor, wear that, so be ready to scrap if you're going to go into DC. And immediately prior to this, at lines 8 through around line 13, he references again the fact that the Oath Keepers would not be allowed to bring firearms into the district and to prepare accordingly. Again, this comports with the preparations for that quick reaction force that ended up being stationed in Virginia on January 6th. And so again, throughout, you see this preparation where they're preparing to fight. They're using he's saying in these private communications, in this members only national call, and then subsequently in private signal messages to prepare physically, to acquire gear, to be able to have a protracted, prolonged fight if needed.
All right, thank you, Mr. Lewis. I think we can break now. I would move for the admission of Exhibit 20.
The transcript?
Yes, and to anticipate, it is admissible under 703. It's also non-hearsay because it's, again, being offered for the fact that the statements were made, not for the truth.
Really?
I suppose I ought to do some voir dire on it,
What would you like to board the witness on?
whether or not he compared it to the actual video, whether he was at the court, where this was introduced, those type of questions, Your Honor.
Yes, you can ask a few questions.
So, Mr. Lewis, were you at the court in which this transcript was introduced as an exhibit?
No, sir.
And did you compare this transcript word for word with the audio that apparently is in your possession of that go-to meeting?
I do not believe I represented that the audio of this was in my possession.
Okay. And so, do you have any other independent basis by which you could authenticate the content of this particular document?
It was entered into federal court by a defendant in this case. And so to my mind, as an extremism researcher, the fact that a seditious conspiracy defendant willingly entered a transcript from his organization into evidence speaks to the veracity of the document itself.
Your Honor, I don't have any further questions. He wasn't at the court in which it was introduced, nor has he compared it to apparently an audio that exists for the meeting itself. So, I mean, certainly understand the reliance that he's made as an expert on it, but as to any other purpose of the exhibit, we'd object.
All right, I'll admit it under 703 is something that's relied upon, and then counsel can certainly make arguments about the authenticity or otherwise the content of it. That's a continuing objection that I'm still working on. So it's admitted for that purpose. So Exhibit 21. Otherwise, I want to be respectful of people's. If we do have a 45-minute break, is that going to be enough time for the parties to take everything that they need to take care of before we pick back up again?
It's fine with us, Judge.
Can we do an hour, because I'm just going to pick up something?
I understand. We'll come back at 1:45. We'll probably take a short break, basically in the afternoon, going right up until 4:30. So plan to go I'll take a comfort break for folks, but we'll try and move essentially through the rest of the afternoon. So we'll come back on at 1:45. Stand recess. Practically, we're talking about.
Wow, let me tell you, that was just amazing listening to what they had to say there and what is going on. Hopefully you guys caught more than I did there. I believe they're on lunch break right now, and I will have to go back and re-listen to the last little bit at what time they will be back. I'm assuming it'll be an hour from now that it's ended. This is what happens when you work for a living, trying to do your regular job on top of doing what your passion is, which is reporting on what our government is doing and trying to be to everything that our mainstream media refuses to represent us Alaskans in its entirety, not just their 30-second spin. Make sure you have liked and shared this video. I am going to go ahead and end this right now, and I will be coming back in an hour from now with part 2 for today. You can find us on YouTube, Twitter, Facebook, Rumble, all at Politadick. And here by the end of the week, our website will be back up and running. Normally you would be able to catch this live stream live on our website at politadick.com. And as soon as we get done transferring to a new website host provider and get all those little details finalized, we'll be back up and running there too. And as soon as the site gets back up and running, please go there, click on that support button. It's your proceeds that made this possible today, made this live video for me to be able to do this for you so that we can all participate. It is your support that has made this all possible, and thank you. It has been greatly appreciated. I keep using everything you guys help and donate and put it directly right back into what I'm doing here. If I could get all 5,000 plus of you that follow Politadick to donate just $5 a month, I'll guarantee you, I will have people all over the state doing what I am doing right now. They will be sitting in school board meetings. They will be sitting in assembly meetings, city council meetings. I personally will be sitting in Juneau waiting for them to come out of their committee meetings or their floor sessions, waiting to interview every single one of those Alaska legislators coming walking out the door, asking them, what the hell just happened? Or let me give you a pat on the back, why don't you brag about what you just accomplished? The latter one probably wouldn't happen very often. It would be more, what the hell did you just do? Would probably be how the conversations would normally start out. It is your support that can make that happen. And I would love to be able to do this full time. And you guys could make that happen just by becoming a supporter. $5 a month, cost of less than a cup of coffee at the local espresso stand. If you're like me, I drink mocha breves, so I'm over that $5 limit just in one purchase when I go to a coffee stand. And your support can help change all of that. If you were to make a $200 donation, I will send you a Make Alaska Great Again hat. Pick your color and I will send it to you free of charge with every $200 donation that is made. And like I said, our website should be back up and running again by the end of this week. We could be found at politadick.com. Right now it currently has just a blank splash page there as I left my last host, and it is being mitigated into the new host, but everything should hopefully be up and fully re-functional again by the end of this week. Again, like and share this video. I will see you here in about 50 minutes or so. Thanks again, and see you in just a bit.